My Lord can continue to take over from there.
We'll go to the respondents' objections to documents tendered by the petitioners at the trial. My learned brother, my immediate right, will read the ruling.
Right. Thank you. We want to take on the respondents' objections to documents tendered by petitioners at the trial. In the course of the hearing of this petition, objections were raised by the three respondents. First, to the validity of the witness statements on oath proposed to by some of the witnesses of the petition. Specifically, EW12, that is petitioner's 12th witness, Eguma Friday. PW13, that is Grace Timothy. PW14, Grace Ajagbona. PW15, Abidemi Joseph. PW16, Ms. Edosa Obasa. PW17, Ms. Aleri Ayuba. PW18, Ms. Sadia Mohamed Haruna. PW21, Mr. Samuel Odunta, a statistician. PW23, Janet Nuhu Turaki. PW24, Christopher Bulus Ado. PW25, Victoria Sani. PW26, Hitler Egwonu Nwala, a forensic expert. And PW27, Mr. Mike Enahoro Eba, a legal practitioner. These are those who witness statements. Witness statements were filed or deposed to long after petition was filed, and so did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act 2022. That is stating that election petition shall be accompanied by a list of the witnesses that the petitioner intends to call in proof of the petition. This objection was argued comprehensively by counsel to parties, and the ruling on it deferred by the court till final judgment. Objections, therefore, were also raised by the respondents to virtually all the documents tendered by the petitioners in proof of their petition. But unlike the earlier objection on witness statements, counsel only gave notice that they will give reasons for those objections in their final addresses. They have since fulfilled their promise by filing separate addresses on those objections. The petitioners, on their part, also objected to some of the documents tendered by the respondents in the course of their defense and gave notice that they will also give reasons for their objections in an address to be filed at the close of the evidence. They, however, seem to have had a change of mind and have not filed any written submissions as promised. I am therefore left with only the objections of the respondents. I now proceed to consider the said objections of respondents. 1. The validity of witness statements on oath of PWs, that is petitioners' witnesses, number 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, that did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act 2022. This objection was taken and comprehensively argued by First Respondents Council on 8th of June 2023, when PW12, Mr. Eguma Omachono Friday, the presiding officer in the disputed 25th February 2023 presidential election, tried to adopt his witness statement on oath, which he deposed only on the 5th, which he deposed to only on 6th of June 2023, long after the petition was filed on 21st March 2023. Subsequently, when the petitioners called their witness numbers 13 to 18, 21, 23 to 27, who also only deposed to their witness statements in the same June 2023, long after the filing of the petition and even after hearing of the petition had commenced, Respondents' Counsel again raised and adopted the same objections against those witnesses and their witness statements. As explained earlier, the thrust of the objection, which was championed by Chief Wale Olanipeku SAN for second respondent, was anchored on paragraph 4.5b of the first schedule to the Electoral Act 2022, requiring that the election petition shall be accompanied by, among others, witness statements on oath of the witnesses the petitioner intends to call in proof of the petition. Learned Counsel argued that insofar as the witness statements on oath of the said witnesses of the petitioners did not accompany the petition of petitioners as required by paragraph 4.5b and 6 sub 6 and 7 of the first schedule to the Electoral Act, they were incompetent and cannot be relied on by petitioners or the witnesses concerned. It is irrelevant. Counsel argued that the said witnesses came to testify on subpoena issued to them by this court as paragraph 4.5b of first schedule to the Electoral Act makes no distinction between ordinary witnesses and those who were testifying on subpoena. Then that argument was taken, and after hearing the argument, this is our resolution. Now, this contention of the respondents has far-reaching consequences, as its resolution in favor of respondents will result in the court discountenancing the evidence of all the presiding officers, namely PEW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25, who were in the polling units in the election and so were eyewitnesses to the alleged failure by INEC to transmit and uphold the election results to IREF, a major pillar of the petition. It will also result in discountenancing the evidence, oral and documentary, presented by petitioners' two expert witnesses, PEW 21 Samuel Odunton and PEW 26 Hitler Nwala, but also their last witness, Mike Enauro-Eba, PEW 27, who alone testified on the non-qualification of second respondent for the election and tendered documents in that direction. That is, even as we must not fail to remind ourselves that the relevant facts in the petition and replies of the petitioners that will have supported the evidence of PEW 21, 26, and 27, Mr. Samuel Odunton, Hitler Nwala, and Mike Enauro-Eba, have already been found incompetent and struck out by this court while ruling on the applications like preliminary objections of the respondents. Coming back to the objection of the respondents, that paragraph 4.5b of the first schedule to the Electoral Act 2022 does not make any dichotomy between ordinary witnesses and those testifying only on subpoena as regards the duty to front-load witness dispositions along the petition. So the evidence of PEW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, whose witness statements or notes were not front-loaded with the petition are incompetent. Paragraph 4.5b of the first schedule to the Electoral Act 2022 reads thus, and I want to mention it. It says the election petition shall be accompanied by B, written statements on oaths of witnesses. And clearly, this provision, particularly the word witnesses, whose written statements on oath the lawmakers require that shall accompany the election petition, must be given its literal interpretation. See the recent decision of this court in Ogba and Vincent, and then that of Senator Ararumi and INEC, all citations supplied. The unreported decision of this court also of 17th of July 2020 in Advanced Nigeria Democratic Party ANDP, versus INEC and two others, appeal number EPT 406/2020, and People's Democratic Party versus Okogwa, citations supplied on the issue. Where are clear, like paragraph 4.5b of first schedule to the Electoral Act is, particularly the unqualified witnesses, in quote, employed there, the court has no duty than to give it its literal meaning. Now, in Advanced Nigeria Party, Democratic Party MP versus INEC, in appeal already cited, presided over by Justice Ige Nimpa and Agim, our colleagues, as Agim as he then was unanimous in his decision on the point in issue. Ige JCA, pronouncing the leading judgment, said, I am of firm view that if Section 145 of the Electoral Act 2010 and paragraph 54 of the first schedule to the Electoral Act 2010 are juxtaposed with other three rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019, it is eminently clear that other three rules 2 and 3 of the Federal High Court Civil Procedure Rules is outrightly inapplicable to the situation the appellants find itself in this case. Paragraph 3 and 4 of the first schedule to the Electoral Act 2010 contain express and adequate provisions as to what the contents of a petition should be and the documents that must be front-loaded and accompany an election petition, including a list of witnesses that the petitioner intends to call, improve of the petition, and more importantly, written statements on oath of witnesses. Well, there is also, it says further, there is no dichotomy between witness statement mentioned in paragraph 4.5 of the first schedule to the Electoral Act in respect of witnesses' statement on oath of witnesses and witnesses' statement on oath of a subpoenaed witness. There is no distinction between ordinary witness and subpoenaed witnesses under paragraph 4.5 of first schedule to the Electoral Act. In essence, paragraph 4.5 of first schedule to the Electoral Act covers witness statements on oath of all categories of witnesses the petitioner intends to call at the trial of his or her petition, unquote. In Senator Ifeanyi Ararume and INEC, this court also, presided over by my Lord Justice Samani JCA, to concurrence of my brothers Owade Akimbami, Balaji Yusuf, and Bayero JCA, again confirmed this position when, in that decision, was held. Learned counsel for the appellant has argued that PW2 was before the court on subpoena, therefore the tribunal could not turn around to prevent him from testifying. It is not disputed that the same witness was before the court on subpoena ad testificandum, but it must be realized that the witness was subpoenaed on the application of the appellants. He was not summoned by the tribunal in the exercise of their powers pursuant to paragraph 41, 5, and 6 of the first schedule to the Electoral Act. He was therefore, for all intents and purposes, witness for the appellants. In that respect, his written statement on oath was subject to the requirements of the law as stipulated by paragraph 4, 5 of the first schedule. Strict compliance with paragraph 4, 5 of the first schedule to the Electoral Act is mandatory. It is of such a nature that there is sanction in subparagraph 6 of paragraph 4. This point was also earlier made in petition 03. Also see the decision of PDP and Okabwe, and then Ogba and Vincent, Midra and Patricia Ete, Awoyemi, Lasun and Awoyemi. All these cases have their citation here, and they already referred to in our earlier 3. Okay. It is of interest that in all these cases, the earlier decisions of this court, Midi Ram versus Patricia Ete and another, and Lasso versus Awoyemi, relied on strongly by Mr. Chris Uche SAN, for the petitioners were cited and considered but departed from by this court. Quite remarkably too, in his book, Modern Nigerian Election Petitions and Appeals Law, published in November 2017, which book Chief Chris Uche SAN, the lead counsel for petitioners herein, wrote glowing for Dr. Mr. Kelechi Peter Ikoroga, Esquire, had this to say at pages 134 to 140 while commenting on this same issue, the SR position of this court in Omidira and Ete, and then Lasso versus Awoyemi. There, Chief Uche SAN, who is incidentally present here, says, just like a petitioner in an election has 21 days from the date of the result of the petition to file his petition, otherwise such a petition becomes statute bar, there is also a time limit to the period within which a petitioner is to file a deposition or other document not filed along with the petition. Thus, all evidence required in proof of a case must, as a precondition to exercise jurisdiction, be brought within the stipulated time frame. That is to say, 21 days after the declaration of the result. The Supreme Court has consistently, in the long line of cases, insisted on this strict and inelastic approach in enforcing the electoral laws. Thus, the efficacy of the decision of Omi Diron versus Sete, see also Lasso and Awoyemi, citation supplied, wherein the Court of Appeal held that it will be appropriate to meet the justice of the case for a tribunal to order the filing of witness depositions by subpoenaed witnesses outside the stipulated time frame has been watered down, in that all evidence required in proof of the case must be brought within stipulated time frame. See the case of Ogba and Vincent, where the Court of Appeal, Agim JCA, as it then was in lead judgment, held. I think that this court in Omidira and Ete and the Supreme Court in Oke and Mimiko adopted different approaches in addressing the issue of whether a tribunal or a court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election proceeding. Omidiron's case did not strictly enforce the time limits prescribed in Section 141 of the Electoral Act 2006, the provisions in the first schedule thereto in prohibiting the introduction of additional facts in the proceedings after the period allowed for filing the petition and closure of pleadings, and paragraph 1 of Election Tribunal and Court Practice Directions 2006, and the content and form of the petition. It held that the purpose of the practice direction is to guide and regulate compliance with provisions of the first schedule to the Act and the Federal High Court rules where applicable. This elastic approach of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the election tribunal and court practice directions as overriding the rules of court in election cases. In Oke versus Mimiko, the Supreme Court approached in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The law has laid out strictissima juris in Oke and Mimiko is that a witness deposition that is not filed along with the petition within 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus: if there was evidence which was fundamental to the determination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition, even if it was being withheld by any person. There are several ways to go about placing same before the tribunal. The Evidence Act is very clear on this, and the petitioner ought to have resorted to that procedure. Put this in italics, we have earlier mentioned it in 03. As earlier said, Chief Chris Uche SAN in his foreword to that book glowingly endorsed this author's position and even recommended it to judges like us in these words. The author has ably and remarkably sought to examine the legal framework of electoral legislation within the landscape of judicial decisions emanating from disputes arising from elections in the country, from the preparation of the election itself through the pre-trial proceedings, the actual trial, the judgment and trial proceedings. This book truly stands out in the midst of several other books in this field. As an avid participant in electoral litigation, I wholeheartedly recommend this book to all, particularly to lawyers, judges, students of electoral laws, litigants, and as well as all stakeholders in the development of our constitutional democracy, unquote. I shall hold counsel to his words, not just because they are coming from him, but also because they are correct. Permit me to still say a word or two on petitioner's contention that Order 3 Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019 permitting parties to file witness deposition of a subpoenaed witness even after commencement of their action applies automatically to election petitions by virtue of paragraph 54 of the first schedule to the Electoral Act 2022. So witnesses' statement essayed of their witnesses filed by them after hearing of the petition had long commenced wherein were in order. Full stop. In the first place, paragraph 54 of the first schedule to the Electoral Act simply states, subject to the express provision of this Act, the practice and procedure of the tribunal or the court in relation to election petitions shall be as nearly as possible similar to the practice and procedure of the Federal High Court in the exercise of its civil jurisdiction, and the civil procedure rules shall apply with such modification as may be necessary to render them applicable, having regard to the provisions of this Act, as if the petitioner and the respondent were respectively the plaintiff and the defendant in an ordinary civil action. This provision clearly makes application of the civil procedure rules of the Federal High Court in election petitions subject to the express provisions of the Electoral Act. It is not the other way around of modifying provisions of the Act to agree with the rules of the Federal High Court as suggested by Petitioners' Counsel. That much, paragraph 54 further clarifies by stating that even where the Federal High Court rules are considered applicable, they shall only apply with such modifications as may be necessary to render them applicable, having regard to the provisions of this Act, unquote. What all that means is that where there is express provision in the Act on a particular situation, such as it clearly is in paragraph 45B of the first schedule to the Electoral Act 2022, that says the election petition shall be accompanied by written statements of oath of witnesses, the provisions of the Federal High Court Civil Procedure Rules will not apply. Fortunately, there is again high authority in support of this position in the dictum of Muntaka Kumasi GSC in Nwankwo versus Yaradua, citation supplied, where His Lordship, after producing paragraph 50 of the first schedule to the Electoral Act, now paragraph 54, had this to say. Say from the above, it is crystal clear that the provisions of the Federal High Court rules are subject to the provisions of the first schedule of the Electoral Act 26, and if there is any conflict between them, the provisions of the rules under the Electoral Act will prevail. It is where there is a lacuna in the provision of the rules provided in the Electoral Act 2006 that the provisions of Federal High Court rules will apply. I shall also add that the Parliament have expressly stated without dichotomy in paragraph 45B of the first schedule that to the Electoral Act that petitioners shall front-load witness statements of their witnesses along with their petitions. It is not within the province of the court to give that provision a different interpretation. It is also no moment that in court's opinion, the say literal meaning of paragraph 45B of the first schedule to the Electoral Act 2022 seems harsh and may not meet the justice of the case, as is being suggested by the petitioners that subpoena is only issued to an unwilling witness, so it is not contemplated by paragraph 45B of the first schedule to the Electoral Act 2022 that the witness on subpoena should also depose to a witness statement before the subpoena to compel the attendance is served on him by the court. If anything, the argument rather brings to mind the very strong admonition of the British House of Lords of Lords, Lord Denning MRL in Dupont Steels Limited versus SIRS, citation supplied, where the learned Lord Scammer in his speech said, "But in the field of statute law, the judge must be obedient to the will of the Parliament as expressed in its enactments. In this field, Parliament makes and unmakes the law. The judge's duty is to interpret and to apply the law, not to change it to meet the judge's idea of what justice requires. An interpretation does, of course, imply in interpreter a power of choice where different constructions is possible, but our law requires that the judge choose that the judge chooses the construction which, in his judgment, best meets the legislative purpose of the enactment. If the result is unjust but inevitable, the judge may say so and invite Parliament to reconsider the provision. But he must not deny the statute. Unpalatable statute may not be disregarded or rejected merely because it's unpalatable. Only if a just result can be achieved without violating the legislative purpose of the statute may the judge select the construction which best suits his idea of what justice requires in any case. That is a settled position of the law, even in this country. See Ndomaeba and the right? Aromolara versus Agoro. Coca-Cola Nigeria, Kinsanya, then Global Excellence cited earlier and Donald Duke. There, my Lord said, the duty of the court is not to deal with the law as it ought to be, but as it is. Paragraph 45B of the first schedule to the Electoral Act 2022, I will even venture to say further, appears to have been inserted by Parliament in further realization of the sui generis time-bound nature of the election proceedings, a point further driven home by the Constitution of the Federal Republic of Nigeria, Second Alteration Act 2010, which introduced, among others, a new Section 285 sub 6 into the 1999 Constitution. That provision states that an election tribunal or court shall deliver its judgment in writing within 180 days from the date of filing of the petition. This time limit for disposal of proceedings, it must be noted, is peculiar to election petition proceedings in our body of laws. It is not found in any other proceeding in the entire body of laws of this country. It thus imposes on the election court or tribunal a duty to properly utilize its case management to pre-hearing session as effectively as possible to carefully plan the future course and particularly its plenary hearing of every petition so as not to fall foul of the maximum 180 days limit. That necessarily includes trimming the number of witnesses where necessary once pleadings are closed in the petition. That is also the point echoed by this court in People's Democratic Party and Chibuzo, Okobu, and others, citations supplied, where my colleague Abadwa JCA said, what is deducible is that witness deposition filed by a witness not listed in the petition cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. It was stressed also by this court hearing that to allow a petitioner to file an additional witness statement at any stage of the election proceedings would destroy the regulated environment that must exist to ensure that both parties to the petition are expeditiously heard and the petition determined within 180 days from the date of the petition. This court observed that such an indulgence will remove the control of the pace of the proceedings from the control of the Constitution, the Electoral Act, and the first schedule to the Electoral Act, and leave it at the whims and caprice of the parties and open the floodgates for all kinds of abuses of the judicial process. Unquote. I think the same point is also deducible from the following. In the dictum of Toby mentioned similar things in Buhari and INEC, and then Buhari and INEC also said a lot about that. We have mentioned it earlier. And then by rules of stare decisis, the decision in Oke and Mimiko and Oba Vincent, decisions of this court is bound not only by decisions of the Apex Court, but also by its own previous decisions. And these are known issues. Victor Rusek and ACB is there, and then ITPP Limited and UBN Limited. See the decision of Ogbuabu GSC. Long and short of all the foregoing is that the objection of the respondents to the witness statements of PW12 Eguma Friday, PW13 Grace Timothy, PW14 Grace Ajagbona, PW15 Abidemi Joseph, PW16 Ms. Edosa Obosa, PW17 Ms. Aleri Ayuba, PW18 Ms. Sadia Mohamed Aruna, PW21, Mr. Samuel Odonta, the statistician. PW23, Janet Nu Turaki. PW24, Christopher Bulusado. PW25, Victoria Sani. PW26, Hitler Ewonu Nwala, forensic expert. And PW27, Mr. Mike Enauroeba, legal practitioner, which did not accompany the petition as required by paragraph 45B for the first schedule to the Electoral Act is hereby sustained, and the witness statements being incompetent are hereby struck out and expunged from the records of this court. The further consequence of that decision is that, given the provision of paragraph 41 sub 3 of the same first schedule to the Electoral Act 2022, stating that there shall be no oral examination of a witness during his evidence in chief, except to lead witness to adopt his written deposition and tender in evidence all disputed documents or other exhibits referred to in the deposition. It followed evidence in cross-examination and all documents reports included, namely PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1B, PAR1C, PAR1D, PAR1E, and PAR1F, and PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD1A, PBD2A, PBD3, PBD4, PB1, PBE2, PBE3, PBE4, PBE5, PBE6, PBF1, PBF2, PBF3, and PBF4, coming from and tendered by the said petitioner's witnesses, namely, as I already listed, P16, 17, 18, 21, 22, 23, 24, 26, and 27 aforementioned are incompetent and are hereby expunged from the records of this court. Other objections of respondents. That takes me to the other objections raised by the respondents to the admission of documents tendered by petitioners at the hearing, which objections they only gave notice that they will give reasons at final address stage. All three respondents filed their submissions on the objections and adopted them on 1st of August 2023. Petitioners on the same 1st of August also adopted their responses to. Before going into the objections, we deem it necessary to first dispose of the preliminary argument of counsel to petitioners that some of the documents objected to by respondents are electoral material certified by the first respondent INEC, which documents parties had agreed at the pre-hearing session that they will not object to. So respondents cannot resile from that agreement and raise objection as they are doing. They even cited section 169 of the Evidence Act 2011 to say respondents are stopped from resiling from that agreement. The simple answer to that argument is that this court, and indeed every court, is bound to act on only admissible evidence. So if a document or piece of evidence is inadmissible in evidence, the court must expunge it, and it must do so even if that will require it to overrule its own interlocutory decisions admitting that evidence. See, and other authorities in that respect. As counsel, as ministers in the Temple of Justice, are therefore within their right and in fact duty bound to draw close attention to that fact, regardless of whatever agreement they may have had with petitioners at the pre-hearing session. In any event, the court is only bound to honor lawful agreements, not unlawful ones, to admit evidence that may well be inadmissible. With that said, I now proceed to the objections as contained in the addresses filed by respondents. Here, I shall take them together as I have done if reasons now advanced for them were canvassed earlier. Now, let's look at first respondents' alleged allegation of improper or non-certification of INEC documents. Counsel to the first respondent in paragraphs 1.3 of first respondent's written address filed on 14th of July 2023 second respondent at paragraph 3.13 of his 20th of July 2023 address, and third respondent in paragraph 1.14 of his written address on objections filed on 14th of July 2023, all argue that that payment for certification is one condition precedent under Section 104 of the Evidence Act 2011 for certification of public documents. They say petitioners did not pay for certification of some INEC documents, specifically exhibits PAJ1, to PAJ37, PAJ38, PAJ39A to F, PAJ40, PAJ41 to PAJ and PAJ41 to PAJ7. There's something wrong. PAK1, PAK13, PAL1, PAL2, PAQ to PAQ14, exhibits PAS1 to PAS20, exhibit PAT1 to PAT17, then PAU1 to PAU17, PAV to PAV20, PAW1 to PAW25, PAX1 to PAX13, PAY1 to PAY18, PAZ1 to PAZ17, PBA17 to PBA27, PBB1 to PBB21, and did not provide any evidence of payment of certification fees. Learned Counsel, all citing the cases of Tabik Investment and GTB, Jimon, Minister of Federal Capital, Emeka and Chuba Ikpeazu, argued that certification fees for the said documents having not been paid by the petitioners, documents remaining admissible and liable to be expunged from the records. Petitioners' response argued in paragraph 4.1 and paragraph 6.0 to 6.2, paragraph 2.123 of their response to second respondent, and paragraph 2.16 to 2.7 of their response to third respondent, that they actually paid certification fees to first respondent for their said documents, and that they were issued receipts by the first respondent. Some of those receipts, they said, were attached to the documents themselves, while others were separately receipted for, including, in one instance, payment of 6,669,301 naira 25 kobo, and another for 150,967 naira 50 kobo. They argued that it was therefore unconscionable of first respondent who collected such huge sums of money from them to turn around and plead non-payment of certification fees. Then Senior Counsel on petitioners' behalf also pleaded the Evidence Act's presumption of regularity of official acts and submitted that it was strange that a public institution like first respondent will come before a court of law to disown documents officially issued by it. In specific response to third respondent's argument, counsel to petitioners argued that Section 104.1 and 2 of the Evidence Act 2011 does not prescribe that the amount paid for certification must be reflected on the certified true copy of the document as part of the certification. So the argument of third respondent's counsel that because the certification of the said exhibits did not carry the amount paid for certification, certification fees were not paid for is clearly erroneous. Now, Section 104 of the Evidence Act provides every public officer having custody of public document which any person has a right to inspect shall give that person on demand a copy of it and payment of the legal fees prescribed in that respect, together with a certificate written at the foot of such copy that it is a certified true copy of such document or part of it as the case may be. Secondly, the certificate mentioned in subsection 1 of this section shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies shall be called certified true copies. There is nothing in the foregoing provision, particularly subsection 2, dealing with what should appear on the certification, that suggests that the fees paid for certification of a public document should also appear on the face of the document, like the date, name, and official title of the public officer issuing the document, as required by subsection 2. Payment of certification fees is only a condition precedent to the certification, so it could be stated in any other place, including another document. That point, this court also made plain in answer to a similar argument in Dagash and Bulama. And see also Uzoman, Sodike, ANPP, and PDP, all these were made clear there, where it was held that certification in fee contained in separate document is sufficient. In this case, not only is there by petitioners first in the form of SBPD, showing payment by petitioners to INEC of the sum of 150,967 naira 50 kobo for some documents. There is also a second INEC receipt in INEC's own letterhead and attached to SBPAF 4C. This latter document evidencing further payment of certification sum of 6,696,301 naira 50 kobo by the petitioners, Atiku/PDP legal team, shows that it was made Friday receipt number RRR 270-842-65-3235 and on INEX receipt number 069727 of 25th of May 2023. It specifically states on its face docs the sum of 6,696,301 naira 25 kobo only, being payment for CTC IPO electronic of a copy of data level number, data level, although not very legible, with time, then stamp, event history, polling units of EC8As and S yet to be uploaded from EC9 and other documents 2023 presidential election on foot. All that, in my opinion, is sufficient evidence of certification fee payment. Even more so, when the receipt indicates that the said payment also covers other documents outside those specifically mentioned therein. The burden had thus shifted to the first respondent INEC to show that the monies it received from petitioners for certification fee payment did not cover the documents they are now talking about, which documents INEC interestingly also certified. That burden INEC never discharged, especially when account is taken of the fact that it did not even give the amount assessed, if any, that petitioners were owing them for certification. By the provisions of Section 1041 of the Evidence Act, an applicant for certification of public documents is only obliged to pay. What is more, the mere fact that respondents certified the same documents for petitioners, coupled with the evidence of certification fee payment by petitioners in Exhibits EB and EAF 4C, sufficiently triggers the provision of Section 168(1) of the Evidence Act 2011 that says when any judicial act or official act is shown to have been done in a matter substantially regular, it is presumed that formal requisites for its validity were complied with. This ground of the objection is therefore overruled. Then on the issue of alleged engravement of certification, it was also argued by the respondents relying on the Gurian Ahmed that certification of the same documents was done by public officer of INEC by engravement of his name, official title and date instead of subscription, so that also he said it invalidated the documents and rendered them inadmissible. I've carefully perused the same documents and verified that unlike the Gurian Ahmed, the documents in issue here bear the long hand signature of the relevant certified public officer of INEC. That, in our opinion, is substantial compliance with Section 104 of the Evidence Act and attracts the presumption of genuineness via Section 146 of the Evidence Act. First and second respondents in particular also argue that the PAH1, PAH2, PAH3, and PAH4 tendered by PW21, Mr. Samuel Odunton, and PAR-A to F tendered by PW26, Mr. Hitler Nwala, were made during pendency of this proceeding or in anticipation of it, and therefore inadmissible in evidence by virtue of section 3.3 of the Evidence Act 2011. In their response, the petitioners argued that the said documents were made pursuant to the orders of this court, pursuant to section 146(1) of the Electoral Act 2022, permitting them to inspect documents, so they were properly before the court. Much as I am not oblivious of our earlier ruling, that these same documents coming from witnesses whose witness statements on oath were not front-loaded with the petition are incompetent and so already struck out. I'm also of the opinion that the petitioners seem to completely misconceive the objection raised by the respondents, which is to the effect that the same documents, having been undeniably made during the pendency of this petition or in anticipation of it, are rendered inadmissible by the principal law guiding admissibility of evidence, the Evidence Act 2011 and section 83 thereof, sub 3 thereof. It is therefore lame of the petitioners to find their breach of that provision on account of the orders of this court made pursuant to section 146(1) of the Electoral Act 2022, that they be allowed to inspect polling documents in the custody of INEC. In any case, section 146(1) of the Electoral Act 2022 merely states that an order for inspection of a polling document or any other document or package in the custody of the Chief National Electoral Commissioner or any other officer of the Commission may be made by an election tribunal or a court of competent jurisdiction if it is satisfied that the order required is for the purpose of instituting, maintaining, or defending an election, unquote. This does not in any way give petitioners a leeway to adduce evidence in breach of section 83 sub 3 of the Evidence Act 2011. Section 146 of the Electoral Act 2011 and the interim orders of this court only permitted the petitioners to inspect election documents for the purpose of instituting or maintaining an election petition. Nothing in that provision allows the petitioner to file evidence, let alone the bulky expert reports as in exhibits PAH1 to 4, PAH1 AF, PAR1 A to F during the pendency of the petition. The whole idea behind section 83.3 of the Evidence Act 2011 is to eliminate the danger inherent in allowing a party to manufacture and bring in evidence specifically tailored in anticipation of a case, or wants to produce such fresh evidence after the case has begun and parties have fully joined issues in it. That is exactly what the petitioners sought to do with exhibits PAH1 to 4 and PAR1 A to F, prepared and filed by experts long after pleadings in the petition had closed, where respondents will no longer have opportunity of retaining their own experts to respond to the evidence presented against them in the same reports. I'm in agreement with the respondents and hereby uphold their objection that the said reports, which were admitted in evidence as PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1B, C, D, and E, and F are without prejudice to our earlier decision that the incompetent is also rendered inadmissible in evidence by virtue of section 83 sub 3 of the Evidence Act 2022. No, sorry, Evidence Act 2011. Then the next one is the inadmissibility of election documents tendered as exhibits by petitioners on grounds of absence of pleading to support them and consequential irrelevance to the petition. The respondents' arguments here are given. So we now now skip that to the resolution. We've seen that, and the resolution we have is, it appears clear to me that the respondent's objection here is misconceived and founded on isolated reading of paragraph 143 of the petition, where the petitioners aver that the first respondent and his agents wrongly and deliberately entered wrong scores results for the underlisted 22 states, namely Abia, Damawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Cross River Delta, Edo, Enugu, Gombe, Imo, Kaduna, Katsina, Kebbi, Niger, Osun, Taraba states. Pleadings, they say, of party is not read in that isolated manner to get at a party's complaint. Pleadings must be read holistically to get at the complaint in issue. If that is done, as it should be done, the respondents would have come across where petitioners left no one in doubt that their complaint about the election is nationwide and not isolated to only some few states. That much is clear. First, from paragraph 107 of the petition, where petitioners aver that the petitioners shall give evidence to show the election results as purportedly declared by first respondent in respect of each state of the Federation, including the Federal Capital Territory, the details of which are contained in the table below, and table was given wrong. Then, they proceeded to list each of every state of the Federation. They also gave in the table wrong election figures declared by INEC for each state and FCT. Then in paragraph 147 of the same petition, they listed 60 different types of sets of documents they intended relying on to prove the said environment. In paragraph 107 of the wrongness of the results declared by INEC for each state and the FCT, the presidential election. Among those documents listed by them are BIVA's CTC reports, B, Forms EC8 series, then EC8A, EC8B, EC8C, EC8G, EC8G-A, EC8E. That's a certificate of return received by petitioner's agent at the election. C, summary of the total registered voters on unit basis. D, summary of PVCs collected on unit basis. E, data and event logs from all BBA's machines used in the election. And F, PVC collection records. These documents were specifically listed in paragraphs 147.1, then 6, 36, 37, 56, and 57 of the petition. These are the same amendments to documents respondents are asserting were not pleaded by the petitioners and so irrelevant and inadmissible in evidence. They are indeed wrong. This ambit of the objection of respondents is therefore overruled and rejected. Then objection made by only the third respondent. The next set of objections to documents tendered by the petitioners were raised by only third respondent. We now proceed to consider them. Admissibility of video clips. Arguments were advanced there on, okay. Yes. So we say that my about the opinion that the contention is also conceived, especially when regard is had to paragraphs 1, A, B, E, F, G of the certificate of authentication of the said video clips made by PW19 Dr. Ter. The authentication required by Section 84 of the Evidence Act, in the circumstances the video clips in issue were made, the statements assuring the court that they are in exact same state they were in the internet from where Dr. Ter, PW19, downloaded them to his laptop computer and subsequently to his flash drives before bringing them to this court. That much is evident in the contents of Dr. Ter's certificate in EAF 4B above. For the same reason, the argument of Dr. Ter is not the argument that Dr. Ter is not in position to answer questions on the same clips, and so his evidence on them is hearsay, is also non sequitur. Then there is also the issue of dumping of documents on court as ground for admissibility. This one. Okay, that's part of the issue which will be considered deeply. see, that is it. This is, okay. Some of them are listed. The simple and straightforward answer to this argument is that the issue of dumping of documents on court, which expression in any case suggests that the documents so dumped are already in evidence before the court, only goes to the weight to be attached to the documents by the court. On this reasoning, this ground of the objection is rejected and overruled. Then also there is allegation that some documents tendered were either made during pendency of this proceeding and anticipation of it by present authority. We've done a little consideration of this earlier. So we'll go to number 3. They said also that SV's PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2A, PBD3, and up to PBF4, tendered by the petitioners through PW27, Michael Nauru Eva, to show second respondent's non-qualification for the presidential election on grounds of his alleged convictions to fine in the United States of America, forgery of certificates and dual citizenship are irrelevant to the proceeding and so inadmissible in evidence, petitioners having not pleaded necessary facts in their petition to support them. This also was looked at by us, and okay, and I have already ruled while considering the preliminary objection of the respondents to the petition and replies of the petitioners that paragraph 146 of the petition, where the petitioners averred to non-qualification of second respondent for 2023 presidential election, was bereft of facts to sustain it. I also held that the fresh facts of second respondent's conviction, like fine by district court in Illinois, in United States, alleged forgery of documents and dual citizenship, all of which petitioners only introduced for the first time in their replies, were incompetent. They ran foul of both paragraphs 4.1b and paragraph 16.1b are incompetent, liable to be struck out, and were indeed struck out. I'm also aware that we have just few seconds ago ruled here in this judgment that evidence of PW27, though through whom they say the documents as this now impeached by third respondent were brought in, is incompetent for non-compliance with paragraph 4.5b of the first schedule to the Electoral Act. Those rulings constitute issue as super, binding not only on the parties but on this court too, meaning further that this court cannot depart from them. See Franciscano and Afriban, and also Lawal Daudu and Kadosu and Daniel and all that. Consequently, the objection of third respondent to the admissibility of this evidence earlier highlighted, the objection is hereby upheld, and the said documents are further ruled inadmissible and expunged from the records of this court. Summary of all the foregoing is that 1. The objection to the evidence adduced by PW12 witness Eguma Friday, PW13 Grace Timothy, PW14 Grace Ajabona. They said all those ones we have mentioned, and also it was recouched here, we say that the objection is there, Mr. Bell, that evidence together with the documents, reports included, tendered by the same witnesses, are hereby expunged from the records of this court. Secondly, the objection of respondents to SV's PAH1, PAH2, PAH3, PAH4 made by Mr. Samuel Odunton, PW21, and SV's PAR1A to F made by Mr. Hitler Wala, PW26, is also further upheld, and the same documents already held incompetent and inadmissible by earlier rulings are again hereby pronounced inadmissible in evidence on this ground too. Then the third one now is this, the objection of third respondent to the admissibility of this PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2A, PBD3, PBD4, PBD1, up to PBF3, PBF4, tendered by PW27, Mr. Mike Onaurupa, is also upheld, and the said documents are further ruled inadmissible and expunged from the records of this court. Save for these ones mentioned above, all other objections of the respondents, the documents tendered by the petitioners are overruled. Well, at this level, I hand over, like my brother said, to my leader to continue with the judgment. Thank you.
I now consider the substantive matter, the substantive petition. However, I wish to state that despite our conclusions above on the objections raised by respondents, the documents tendered by the petitioners, I'm still reminded to evaluate evidence abuse and consider merits of the petition. The only evidence I shall not revisit is the PVD, PVD1A, PVD1C, 1B, 1C, 1D, 1, PVD1A, PVD2A. PBF 1, 2, 3, 4, and 4, relating to second respondent alleged non-qualifications that were tendered by PW7 at 27. Mr. Mike Onaurupa Eba, the said documents in our view being bereft of leading to sustain them of the liberal stated earlier in this judgment. Coming to the hearing, the petitioner has called a total of 27 witnesses and closed their case on 24th June 2023. The respondents opened their respective defenses starting from 3rd day of July 2023. The third respondent called one witness as one of his staff, RW1, and closed the case. The second respondent also tendered documents and called one witness, RW2. The third respondent did not call any witness but tendered documentary evidence. At the close of the case of the party, the court ordered the addresses. The addresses were filed and scheduled. In the final address, 46th respondent filed on 14 July 2023, the learned leading senior counsel of the respondent, Mr. A.B. Mahmoud S.M., raised 4 issues as follows. 1. Whether having regard to section 47 subsection 2 and 3 of the Electoral Act 2022, paragraph 38 and 92 of the regulations and guidelines for the conduct of elections 2022, and totality of evidence adduced at the trial, the inability of the first respondent to transmit the polling unit results electronically in real time using the Beavers device to the RF portal confused non-compliance with the Electoral Act, if such substantially affected the outcome of the presidential election held on 25th day of February 2023. 2. Whether there exists cogent and credible evidence of corrupt practice to warrant the nullification of the presidential election held on 25th day of February 2023. 3. Whether going by the provisions of section 131 and 137 of the Constitution of Federal Republic of Nigeria amended, the second respondent was at the time of the presidential election held on 26th day of February 2023 not qualified to contest the state election. 4. Whether upon proper construction of section 134(2)(b of the Constitution of Federal Republic of Nigeria 1999, the requirement that the candidate must score not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation of the Federal Capital Territory Abuja, means that a successful candidate must specifically score at least 1/4 of the votes cast in the Federal Capital Territory Abuja in addition to 2/3 of all the states. The second respondent, through his counsel, Wale Ulan Tekulu, filed his written address on 14 July 2023. He raised for determination 4 issues which were listed as follows. 1. Consider the relevant provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, the salient provisions of the Electoral Act 2022, as well as the admissible evidence on record whether the election of the second respondent into the office of President of the Federal Republic of Nigeria on 25th February 2023 was not in substantial compliance with the principles and or provisions of the Electoral Act 2022. Two, in view of the clear provisions of the Constitution, the Electoral Act 2022 and the plethora of judicial precedents on the criteria for qualification of candidates for election to the office of President, coupled with the peculiar circumstances of this petition, why in the petitioners pleaded no fact in support of their allegation of non-qualification of the second respondent, whether the second respondent was or is not yet eminently qualified to contest the president election of 25th February 2023. 3. Upon the combined reading of Section 134 and 299, as well as other relevant provisions of the Constitution, Section 66 of the Electoral Act 2022, and other relevant statutes, whether the second respondent has not satisfied the necessary constitutional and statutory requirements to be declared winner of the presidential election of 26 February 2023 and return as President of the Federal Republic of Nigeria. 4. Considering the constitution of the petition and the child evidence abuse, whether this own court can accede to any of the released JM acclaimed by the petitioner. The child respondent, through her lead counsel, filed final address on 14 June 2023. Similarly, 4 issues were generated for determination. 1. Whether, having regard to the relevant and admissible evidence led by the parties, the conduct of the president election held on 25th day of February 2023 was mediated by non-compliance and corrupt practices that were substantial enough to directly attributed to the second respondent as to have affected the outcome of the election and to justify nullification of the election in a manner envisaged by the applicable provisions of the Electoral Act 2022. So, whether the burden of proving that said petitioner and not second respondent got majority of local votes cast and satisfied the constitutional requirement of having 1/4 of the votes cast in each of at least 2/3 of all states of the Federation and the Federal Capital Territory to be declared and returned as the winner of the presidential election held on 26 February 2023 has been discharged by the petitioner. 3. Whether, having regard to the issues joined and evidence led on the qualification of the second respondent to contest in the presidential election held on 26 February 2023, the petitioner has established that the second respondent was not qualified to contest the presidential election as provided for in the Constitution and the Federal Republic of Nigeria, 1999 as altered. And 4. Whether, having regard to the totality of the evidence led by the parties and the applicable law, the petitioners are entitled to succeed on any of the relief sought in the petition at all, or that the petition ought to be dismissed in favor of the respondent. In response to the addresses filed by the first, second, and third respondents, the petitioners, through their leading counsel, is Chris Uche, SAS, filed their respective written addresses on 21st July, 22nd July, and 23rd July 2023. The petitioner's senior counsel filed separate written addresses in response to each of the first, second, and third responder addresses. The issues for termination raised in the 3 written addresses filed by petitioners in response to each of the written addresses of each of the respondents are the same, and they are: 1. Whether the return of the second respondent in the election to the office of the President of the Federal Republic of Nigeria held on 25th day of February 2023 was not invalidated by reason of substantial non-compliance with the provisions of the Electoral Act 2022 on electronic transmission of results for collection and verification. 2. Whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 25th day of February 2023, having not secured 1/4 of the valid votes cast in the Federal Capital Territory of Abuja, as required by the Constitution of the Federal Republic of Nigeria, 1999, as amended. 3. Whether the second respondent was not disqualified under the provisions of the Constitution of the Federal Republic of Nigeria, 1999, as amended, to contest the presidential election held on the 25th day of February 2023, having regard to the alleged order of forfeiture arising from that related offense is acquisition of the citizenship of the country other than Nigeria and presenting a forged certificate to the first respondent. 4. Whether the first respondent was not wrong in returning the second respondent when he was not duly elected a majority of the local vote cast in the election. A look at the issues formulated by the parties will show clearly that though differently worded, they are similar in context and content. It is in the face of this that we choose the 4 issues formulated by the petitioners, albeit with necessary modifications to anchor the determination of this petition. The issues or determinations as modified are as follows. 1. Whether the return of the second respondent in the election to the office of President of Nigeria held on 25th day of February 2023 was invalid by reason of substantial non-compliance with the provisions of the Electoral Act 2022. 2. Whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 25th day of February 2023, having not secured 1/4 of the valid votes cast in the Federal Capital Territory, Abuja. 3. Whether the second respondent was not qualified under the provisions of Constitution of Nigeria as amended to contest the presidential election held on 25th day of February 2023, having regard to the alleged order of forfeiture arising from that related offense, the acquisition of the citizen of the country other than Nigeria and presenting a false certificate to the first respondent. 4. Whether the second respondent was duly elected by majority of the local vote cast in the election and the first respondent was right in returning him as duly elected. So we go to issue number 1, which is whether the return of the second respondent in the election to the office of President of the Federal Republic of Nigeria held on 25th day of February 2023 was invalid by reason of substantial non-compliance with the provisions of the Electoral Act 2022. Yes, we have considered the submissions of council which were summarized here. So we'll just go straight to the resolution of that issue. This issue of non-compliance is directly standing on the first ground of this petition. Thus, by paragraph 16A of the petitioner stated that the election of the second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2022. By section 1341B of the Electoral non-compliance with the Act is the ground for questioning or challenging an election. Primarily, the law is well settled that the results declared by annexed first respondent in an election enjoy a presumption of regularity. In other words, they are prima facie correct. Section 168 of the Evidence Act 2011 recently applied by the Supreme Court at Tuma, and APC. Where is the urgency? Held as follows. By virtue of Section 168 sub 1 of the Evidence Act 2011, presumptions of regularity in favor of judicial or official acts, including those carried out by INEC. The examples of the subsection are thus: when any judicial or official act is shown to have been done in a manner substantially regular, it is presumed that formal requirements for its validity were complied with. Fortunately, for the appellant and first respondent, it is only a presumption which implies that it is rebuttable. Any person who questions the validity of an act in favor of which there is a presumption of regularity has a duty to rebut the presumption which is questioned and credible evidence. A flimsy or half-hearted rebuttal will not suffice. Lots of course. Any petitioner who complains that the result as declared is either wrong or not in compliance with the electoral act has the onus of proving the contrary. See news of PEPC. This case was brought open by the Supreme Court in the case of Andrew and another but was Annie. Where the Supreme Court, Honorable JSC, held as follows. Well, the time is far gone, we skip those the paper. When you get to judgment, you will see. Generally, it is the law that he who alleges must offer the requisite proof. The petitioners have the burden of proof, and they must succeed on the strength of their case as per their pleading. The level of proof required is twofold. The first level is that there is non-compliance. The second level is to prove that the non-compliance substantially affected the result of the election. The Landed Senior Counsel for the petitioners had in this petition argued that the burden of proof is on the person asserting the positive and not on the person asserting the negative. The petitioners, it appears from their position, tend to cross the line of misconception as to who has the burden of proof in adversarial system of justice in civil cases when the primary onus of proof is on the petitioner who makes all the claims against the respondent in this case. Well, we had started this case of Dache and Gruvian by Ugo JCA in the earlier petition, that's petition number 3. Usually the burden of proof is the case owned by the petitioners to the success of their petition. The burden of proof rests upon the party who substantially asserts the affirmative of the issue. It is fixed at the beginning of the trial by the state of the pleading. If the party with the burden fails or could not discharge the burden, the decision must be against him. The case of Adeboke and Sutra and relied upon by the petitioners was cited in the recent case of Polarin and Augusto, where the Supreme Court by Okoro is held as follows. The quotation is there. It is therefore certain that the terms negative and affirmative are relative and not absolute. The burden of first proving existence or non-existence of an assertion or fact, whether positive or negative, lies on the party against whom judgment will be given if no evidence was produced on other side. In the instant case, it is fundamental to point out that from the pleading, the allegation of non-compliance is generated by the petitioner. Under Section 1341 and 135 of the Electoral Act, the level of proof required for the purpose of the petition is double. There must be proof of non-compliance and the further proof that the non-compliance affected substantially the result of the election. In the face of such an allegation of non-compliance, the court is enjoined by the law not to invalidate an election if it appears that the election was conducted substantially in accordance with the principles of the Electoral Act. All said and done, the petitioners have the primary burden of proving that there was non-compliance and that the non-compliance affects substantially the result of the election before the burden can shift to the respondent to establish that there was no substantial non-compliance with the Electoral Act in the conduct of the election. The petitioners have in their petition pleaded some of the facts relating to their complaint of non-compliance to the Electoral Act of 2022. The key paragraphs of their petition in that regard are paragraphs 18, 22, 23, 25, 28, 29, 35, 36, 37, 38, 39, 40, 44, 46, or 48 of the petition. The respondents joined issues with the petitioners in respect of this issue, and they all denied the facts pleaded by the petitioners. The denials of the first respondent in its reply are very significant. In paragraph 17, 18, 19, 31, 32, 33, 34, 35, 36, and 37 of the first respondent reply to the petition, the first respondent is in great measure denied all the allegations of the petition. in the petition. Since those paragraphs are direct and set denied by the first respondent, the burden of proof remains on the petitioners to establish their claims as required by the law. Apart from the first respondent, who is the primary respondent, due to the fact that it is acts that are challenged in this petition, the second and third respondents, who are the beneficiaries of the declaration of the result, join issues with the petitioners. The second respondent, in his reply to the petition, counted all the petitioners pleaded in respect of the issue. Issue 1 was paragraph 6, part 3, 56 and 57 thereof. The third respondent countered the petitioner's allegation with paragraph 36, 37 and 40 of his reply to the petition. Non-compliance in ordinary parlance means failure to or refusal to do something that you are officially or statutorily supposed to do. See Tulua and another verses. So, I starting Ojiku and Yaradua and Akerti and Muniko. The electoral assembly in an explicit manner has laid out clearly grounds upon which an election can be questioned in section 134 thereof. Then there is section 135 of the Electoral Act, which looks like it provides with section 134 for proper appreciation of the intent of the law. Section 134 and 135 of the Electoral Act must be considered together. An election may be, 1341 says, an election may be questioned on any of the following grounds. B, of which says the election was invalid by reason of corrupt practices or non-compliance with the provisions of this Act. Then 135(1) says an election shall not be liable to be invalidated by reason of non-compliance with the provisions of this Act if it appears to the election tribunal or court that the election was conducted substantially in accordance with the principles of this Act and that the non-compliance did not affect substantially the result of the election. This ground of non-compliance to the Electoral Act has been in all our electoral laws, even from when we had parliamentary system of government. The courts have over the years kept a lot of light on the requirement of the law in proving the allegation of non-compliance. A short chronicle of the decisions of our court will throw more light on the prudential burden of proving non-compliance. For that purpose, we started the cases of Batri and Young, Awolowo and Shagari. We also cited the cases of Buhari and another versus Obasanjo and others, and CPC versus Buhari and others. So in all these decisions, the evidential burden of proof of non-compliance lies on the petitioner, who must first prove that there was non-compliance, and secondly, that the non-compliance has substantially affected the results being contested. Let me say that at the risk of sounding repetitive, that it is after the onus on the petitioner is discharged to the satisfaction of the court, that the onus will shift to the respondent to establish that the results were not affected. It follows, therefore, from the authorities referred to, that for the petitioners to succeed in the allegation of non-compliance, they must plead clearly in their petition the non-compliance and call witnesses or place before the court cogent and credible evidence of such non-compliance. The petitioners need to place before this court evidence based on their pleading, indicating that the non-compliance has affected the vote cast at the election and that the impact is substantial enough to invalidate the election. The petitioners, it must be underlined, pleaded in paragraph 4 of the petition that the petitioners have agents in all the polling units, ward collection centers, local government collection centers, and state collection centers in all the states of the Federation and the Federal Capital Territory, as well as the National Collection Center. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The state agents at the polling units were the ones who were meant to sign and collect duplicates of results from UCSA. The few agents called were state and national collection agents. Largely, their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition.
he was the petitioner's collection agent for Kogi State. In paragraphs 7, 8, and 11 of his statement, he deposed that from his analysis, he discovered various forms of non-compliance and corrupt practices such as suppression of votes, manipulation of beavers machines, manipulation of accreditation, intimidation and harassment of voters, massive printing of ballot papers, etc. This witness did not give particulars of those of these malpractices. There was no forensic report he would submit to support allegations of multiple printing at the polling unit. In PPC and another, and ANIC and others, this court, by Agent Jesse as the Denver, held that it is only a polling agent, a polling unit agent, or a person who was present at the polling unit during polls that can give admissible evidence of what transpired during the polls in the unit. See also Goyal and another versus ANIC, Buhari and ANIC and others. In the instant case, PW1 was not a polling agent, he was a collation agent. When cross-examined, he said he would be wrong to say that he was present when all the ballot papers and boxes were manipulated, that he visited only 20 polling units out of the over 3,000 polling units in Kogi State. He admitted that his party had polling unit agents in all the polling units and that they are still alive. The PW2 is also a collation agent. His witness statement on oath is at pages 213 to 215 of the petition. His statement is similar to that of the PW1. His name is Dr. Solarin Sunday Adekunle. He was the collation agent of the petitioner for Ogun State when the election day. Under cross-examination, he said he only visited 19 polling units out of the 5,040 or the polling units in Ogun State. PW3, 4, 5, 6, 7, 8, 9, 10, 11, and 11 are all collation agents. The evidence of these witnesses centered around the events and the duties carried out by the polling unit agents of the petitioners. They agreed under cross-examination that the polling unit agents functioned very well in their unit. Under our law, specifically in Section 43 of the Electoral Act 2022, polling agents are permitted to be appointed by political parties for each polling unit and collation center. The wisdom in this is for each of the political parties involved in an election to be represented by its own agent. The duties of an agent are to represent the interests of his or her principal. Having regard to the fact that no mortal can be in all the places at the same time, the law allows political parties to have their agents at all polling units and collation centers. It is therefore not anticipated by the law for any political party to appoint an octopus agent with his tentacles in all the polling units and collation centers. This is humanly not practicable. When therefore evidence is required to prove what happened in any polling unit or collation center, it is only the agent who witnesses the anomaly or the malfeasance that can legally and credibly testify. It follows therefore that PW1, 2, 3, 4, 5, 6, 7, up to 11, PW19, 20, and 22, who was state and national collation agents for the petitioners, can only testify of the events in their units or collation centers where they voted or acted as agents and not all over the state of the federation. The polling agents, as presented in this petition, it must be noted, are not shown to be experts. The issue of the analyzing results of the election of the ward local government at the state and national level without calling polling unit agents who witness the real casting of votes and events at the voting unit cannot therefore arise. They cannot validly testify of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What they were told is hearsay evidence. Section 13 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. This court and the Supreme Court in several cases have explained the intent of this legislation. But there are started JAM and OG, UK and the state CASA and the state Ukud and the state Buhari and Obasanjo, it is therefore settled law that hearsay evidence is not applicable to prove a fact of non-compliance with the Act. It follows that the evidence of the collection agents in this case, in this instant case, who are PW 1, 2, 3, 5, and 7, related to the separation of votes, multiple thumbprinting of ballot papers, entering of wrong scores of results, disruption of voting, are inadmissible hearsay and are hereby discontinued. In the instant petition, the petitioners called 27 witnesses and tendered documents and exhibits. The main and crucial complaint of the petitioners from the evidence placed before the court was the inability of the presiding officers employed and used by the first respondents to upload and transmit the polling unit results to the first respondents' result view portal, that's IRES, and the electronic collection system. Of the 27 witnesses called by petitioners, 12 of whom were presiding officers who manned the polling units on the election day, a look at their evidence will bring out the fact of how the presidential election was conducted in terms of the polling units on 26 February 2023. These witnesses are PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25. PW 12 is Yoguma Omar Chuku. The witness was on subpoena. He was the presiding officer in collection unit 07 Ward 3, Abanos of Abia State. His evidence is that the election was conducted as his polling unit and that at the end of the election, the results were recorded on the result sheet and duplicate copies given to the party agents at the polling unit. He stated that he had challenges in uploading the presidential election results from the polling unit to the IRA portal and electronic collection portal. When cross-examined, the PW12 testified that the election was peaceful and that it was the image of the results on Form ECHA that was supposed to be uploaded to the IRA portal. His father testified that the result sheets were delivered at the vote collection center to the annual vote collection officer. He said he was happy with the conduct of the election. PW13, Grace Timothy, who was the presiding officer for a polling unit in Bauchi State, corroborated the testimony of the PW12. He could not upload the results of the election to the IRA, but that the party agent signed from ECHA and that she took the original results to the vote collection center. PW14, Grace Ajabona, whose station was polling unit 6, Ward 1, Yamba West, local government area of Kogi State, equally testified that the election results from her unit from ECHA was signed by her and all the party agents before she took the results to the vote collection center. The PW15, Abidemi Joseph, was the presiding officer in charge of polling unit 047, Ward 9, Maji of Babambola community in Maji, Vileja, Niger State. She gave the evidence also that the election was conducted in her unit and that the results were signed by her and that the party agent before she took it to the vote collection center. He also could not upload the results to the averaging portal or panel. The PW16, Edosa or Bosa, was the presiding officer at polling unit 09, Welu Health Center, Ego Ward 05, Edo State. He equally testified that even though voting went well in the election at her polling unit, she was unable to upload the results of her unit to the RF using the device. She did the manual recording of the results from ECHA and signed the result along with the party agent. The result was equally taken by her to the vote collection center. The same story was told by the PW17, Alheri Ayuba, who presided at the polling unit 05, Garki Ward, 02, FCT Abuja. He used Beavers for accreditation of voters, but could not upload the results through Beavers to ARIA. She and the party agents signed the results, and she took the results to the vote collection center. Even the testimony of Mohammed Haruna Sadia, the PW18, is in the same order. He was the presiding officer for Unit 05, Amak City Center, Ward 06, in FCT Abuja. She testified she could not also upload the results to the average area He entered the results manually to form EC8A and took it to the vote collection center. It is fact that she gave copies of the results to the party agents before taking the original to the vote collection center. Janet Nuhu Turaki, the PW23, who was the presiding officer for Bolori West Ward 04, AB Bomala Danladi Diallo polling unit 03, Gombe State, could not upload the results to IRS after using Beavers to snap the results as recorded in EC8A. He, however, testified that the party agents signed the results with her before she took the results to the Ward Collection Center. The same round of evidence was given by PW24, Christopher Bulus Ardo, presiding officer in Maru Ward 04, polling unit 012 years, Sohor Kaswa, Maru, Zamfara State. In paragraph 9 of his deposition on oath, he said the election was successful except for failure to upload the results to the area. The PW25, Victoria Sani, who was the presiding officer at polling unit 020, Ward 01, Atagarawa local government area of Katsina State, had the same testimony and experience with the Beavers and the issue of uploading results to RS. The testimony of these witnesses were so clear and cogent that the election went well. The only difficulty was in uploading the results to the RS portal. These highlighted witnesses were all called by the petitioners. The witnesses were emphatic that the voting and the election in their respective units went well. The votes were collected and results announced at the polling unit. Party agents signed the results from EC8S. The witnesses called to establish the fact of non-upload of results emphatically and directly testified that the election went well and votes were counted for and sent to the vote collection center for collection of the results. These 10 witnesses were all presiding officers engaged by the first responder for the election of 25th February 2023. There is no gainsaying the fact that under the Electoral Act 2022, election is not just a process, it is a well-regulated process. In fact, in the case of OK and another Vakinimiko, the Supreme Court, what diligence is scripting out the meaning of election held as follows. On this first issue, I will want to hand for support on the case of Abubakar and Yaradua, in which election was defined thus. Election is a process spanning a period of time and comprises a series of actions from registration of voters to polling. Then in Gile and the state, the court by Anguta JSC explained further that election is defined as inter alia, the act of choosing or selecting one or more from a greater number of persons, things, causes, or rights. See Black's Dictionary Special Yellow, 5th edition, page 44. The Export Advanced Learner's Dictionary, page 372, defines it as the action or an instance of choosing by vote one or more of the candidates for position, especially in political office. The process of election commences with the nomination of candidates through political party primaries. Then it moves into the election proper, which entails the voting, collation, and announcement of results. To make this process study clearer and credible, the Electoral Act devotes time into making provisions for specificity of actions and steps at each stage. It will not be out of place, my Lord, considering the strategic and fundamental nature of election, to survey some of the provisions of the law in this respect. The law made provision for accreditation of voters and voting in Section 47 of the Act, which provisions I have reproduced in this judgment. This law has made it mandatory for accreditation of voters for the election to be done with the aid of the smart card reader or any other technological device that may be prescribed by the first respondent. The first respondent exercised the discretion given by the law to prescribe the use of bimodal voter accreditation system, that's BVAS for short, and popularly known as BVAS or BVAS machine. As the name indicates, BVAS is primarily a technological device for accreditation. by paragraph 18A of the regulations and guidelines for the conduct of election 2022, the use of beavers for accreditation is mandatory, and all the poll officers who fail to use it for accreditation shall be accused of dereliction of duties and penalized. It is after a voter passes accreditation that he will be allowed to vote. The bottom line of every election exercise is to choose one out of many or to show affirmation of the approval of the candidate who wins the election to lead the country in the instant case as the president of the country. To achieve this goal, election must be result-oriented and successful. A successful election must produce a winner who is expected to emerge by popular vote, and as specified in Section 134 of the of the 1999 Constitution. It is in this respect that all votes cast at an election must be duly secured, collected, and counted. The Electoral Act is so clear and explicit on the issue of the vote cast and the results of the election. So for that purpose, I produced Section 10(5) of the Electoral Act, which stipulates the steps to be followed. So this provision makes it clear and straightforward that voting for all elections takes place at the polling unit, and that is why the election is won or lost. The law requires that since the election, the present election, unlike others, is not done in one location but throughout the country, collection of votes commences at the registration area, so ward level after voting, then it moves to the local government level, and then to the state collection center, and finally to the national collection center. It is after this that the winner of the election shall be announced. Furthermore, Section 60 of the Electoral Act deals with the counting and collection of votes cast. These provisions of the Electoral Act are very simple, plain, and straightforward, and do not require any technical rule of construction. The law is tight that whether words used in a statute are clear and unambiguous, the courts are enjoined to interpret the words in their ordinary and natural meaning. Words used are to be interpreted in a way that will not clash with and defeat the manifest intention of the legislation. Every legislation is scripted by the lawmakers with a purpose. The court must be careful not to interpret the law so as to create absurdity or make nonsense of the law. See the cases of Imiano and others versus Anekwe and others, Degede and Anek, Guma and versus PEPC and others, Lado and another versus Matari and others. The law as prescribed in Section 60 and 62 of the Electoral Act 2022 does not in any form or sense make any provision for pretension as to any form of counting and collection of the election results other than manual collection. In Oyetola and Ani Supra, the Supreme Court by Agim JC held on transmission of results, the essence and status of the collection system, and the Annex RF portal as follows. Court. As I have said here, there is no part of the Electoral Act requiring the presiding officer to transmit the accredited voters in the polling unit or the polling unit results during election to the Annex database as part of the election process. As stated in Section 62(1) of the Electoral Act 2022, after the recording and announcement of the results, the presiding officer shall deliver them along with the election materials under scrutiny for security and accompanied by the candidates or their polling unit, polling agent, where available such person as may be prescribed by the Commission. This is to enable the Commission compile, maintain, and update on a continuous basis a register of election results. This intention is clear from Section 2 of Section 62, which provides that the Commission shall compile, maintain, and update on a continuous basis a register of election results to be known as the National Electronic Register of Election Results, which shall be a distinct database or repository or polling unit by polling unit results, including collected election results of each election conducted by the Commission in the Federation, and the register of election results shall be kept in electronic format by the Commission at its national headquarters. As their names depict, the collection system and the annex result stream portal are part of the election collected at various stages of the election. So the polling unit results transmitted to the collation system provides the relevant collection officer the means to verify a polling unit result as the need arises for the purpose of collation. The result transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results on the election day. It is clear from the provisions of Regulation 38(1) and 2 that the collection system and result viewing portal are different from the National Electronic Register of Election Results. The collection system and result viewing portal are operational during the election as part of the process. The National Electoral Register of Election Results is a post-election record and is not part of the election process. With this step of the law, let us now assess the case of the petitioners in this petition. The petitioners, as earlier mentioned in this judgment, are claiming that the failure of the first respondent to upload the election results constitutes non-compliance to the Electoral Act. They pleaded in paragraph 14 and 15 of their petition that for reproduce paragraph 13 and 14. So the petitioners by this pleading are relying on the summary of final collation and declaration of results, which are in Form ECGA, in bracket, ECAE, as issued by the first respondent. The issues generated on this were not about the score, but the alleged invalidity of the score and the error of calculation of the score. This pleading was not admitted by the first respondent. In reply, the first respondent raised issues with the petitioners in paragraph 9, 10, 11 of their reply filed on 11 April 2023. Which paragraphs are produced. It is certain law that issues for trial by the court are joined in the pleading, and the parties and indeed the court are bound by the pleadings of the parties. The petitioner's case stands to collapse if no evidence is called on the issue. This is the case of Uruwari and Portland and Mada versus Gitu. In the instant case, the petitioners anchored their case in this issue, on the report of the statistician, forensic examiner, and other experts. The statistician's report referenced by paragraph 14 and 15 of the petition was tendered in court through PW21, Mr. Samuel Odinton. It was filed on 14th of June 2023. The statistician's report was tendered, admitted, and marked exhibit PAH1, PAH2, PAH3, and PAH4 respectively. This report was challenged by the respondent, and in our earlier ruling, we came to the conclusion that it was incompetent and liable to be struck out, and was in fact struck out. Without prejudice to that ruling, I wish to assess its value. Nevertheless, PW21, the maker of the said report, was cross-examined in court by all the respondents, and he showed clearly that he is an unreliable witness. He was contradicting himself on issues around his report, apart from the fact that this witness is a supreme witness whose witness statement of oath was not controverted. He did not present himself as a credible witness. Hearing under the cross-examination by Mahmoud S.M. for the first respondent. I have formal training in information technology IT, as stated so in my written statement. I was commissioned by the petitioners. I was compensated by the petitioners for my work. I am an expert in statistics. Apart from what I stated in paragraph 5 of my witness statement, I have enough experience in my work and election petitions. One does not need to be an expert to read Annex from ECHS. I commenced my work sometime in April. It took me about a month to complete my assignment. I cannot recall any proceeding where I admitted that I am not an expert. I agree that if my primary data is defective or incomplete, my conclusions could not be wrong or incorrect. Could be wrong or incorrect. I also agree that if my methodology is wrong, my conclusion will be wrong. I've seen page 4 of Exhibit PAH1. That page refers to the methodology I used as referring to Form ECHS. I inspected the Form ECHS at the Annex headquarters. I do not know if those Form ECHS are before the court. I am aware that the Form ECHS are stored in the various state headquarters. If what are stated in paragraph 2 and page 4 of Exhibit PAH1 is wrong, my conclusion will be wrong. I've seen column 1 of volume 3, Exhibit PAH4, at page 1, line 1. It refers to polling unit 009 or 6 of Anambra State. When cross-examined by Chivole Olani Tekon SN for the second respondent, the PW21 said, I have seen paragraph 5A of my written statement on oath. It is true that I did not present the report in Khalil and Yaradua. I agree that no pictorial images of the electoral documents are referred to in my statement are attached to my statement. I am aware that PDP won the election in Adamawa State. By my report, we are not satisfied by the votes returned by ANIC in Adamawa State, including the votes scored by the first petitioner. I say so because I am not satisfied by irregular votes recorded in Adamawa State. That is why I sought the deduction of those votes. By my report, the petitioners won the election in 12 states. By my figures, I am not satisfied with the score of PDP in those states because they are printed with irregularities. I am also aware that Labour Party also won the election in 12 states. In all the states won by Labour Party, I have also called for the deduction of those votes. I was in the situation room of the PDP on the day of the election. I have seen the report for Kano State in the PAH2. Furthermore, in response to the cross-examination of the London Senior Council for the third respondent, Father Minister, the PW21 said, it is true that I have been following ANIC activities since 1999. There was a time that ANIC chairman said the results for the 2023 election will be transmitted electronically and real time. I did not hear the ANIC chairman announce 2 days to the election that due to the security and cash crunch, the elections will not be possible to transmit the results as promised. The inspection of the electoral documents was carried out in the presence of agents of PDP. I did not make copies of those documents. I was assisted in my assignment by a number of people. Each of these people played a role. I stated the role played by each of those persons. I have seen volume 3 of my report. The same volume 3 of my report deals with ANIC documents which were not signed or stamped. I did not indicate which of them were not signed or stamped. I have seen the table in paragraph 11.2 of my witness statement. Only 26 states are mentioned therein. In my report on the electoral documents not signed or stamped, I mentioned 28 states. I stated that I analyzed the electoral documents from 36 states. It is true that my candidate's vote cannot be deducted more than once in a unit. I did not conduct inspection of the Beavers report. I am aware that Beavers machine was used for accreditation. I am the only one who signed the report because I was the team leader. I worked in all the states where accreditation took place, including states where PDP won. Thus, the state president of PW21 under cross-examination. It is tried in our law that cross-examination is a formidable tool for the demolition of the case of the opponent. The purpose of cross-examination is to discredit the witness called by the adversary. In the recent case of PDP and others versus Muhammad and others, the Supreme Court held that the primary object of cross-examination is to contradict the evidence of the opponent's witness in order to weaken his case. It is best resorted to in order to test the veracity of the witness. It has in the instant case been clearly established that by cross-examination, the PW1 testimony has lost esteem and value. A close look at the report, Exhibit PAH1 to PAH3, will indicate that the witness was talking of 5,270 polling units, while he claimed that for EC8A series were altered and were not signed. It also talks of 15,002 polling units, while from EC8As were not stamped and signed. Yet all that is contained in the report are figures and data of these forms. None of the physical forms was exhibited in the report or tendered separately by any of the witnesses. In that situation, it is very difficult for the court to ascertain the truth of the allegation that several from ECHA series had a lot of alterations and that they were not signed by the presiding officer. The law particularly requires that the presiding officer must sign the results. Signing from ECHA is subscribing to the authenticity of the results. Where there is allegation that the forms were not signed, it must be clearly proved by the petitioners. The result forms must be presented in court for the court to verify lack of signature, stamp, and any alteration on the form. Since PW21, who authored Exhibit PH3 and PAH4, did not place this in his report, and the petitioners did not call any of the polling unit agents to testify and place the forms before the court to give vent to the allegation of alteration and non-signing of the form ECHS for the 5,270 polling units listed in Exhibit PAH2 and the form ECHS not signed stamped for the 15,002 polling units in Exhibit PAH3. That allegation is unfounded and not true as required by the law. On petitioner's allegation, the first offender fails to collect the election results using the electronic collation system. The petitioners have not been able to prove that the Electoral Act or the guidelines made it mandatory for electronic collation system. I have carefully considered the submission of parties on this issue of non-compliance with the provisions of the Electoral Act and the paragraphs of the regulations and guidelines for the conduct of election 2022. The Independent National Electoral Commission, INEC, the first respondent here is established by Section 153F of the Constitution, and part of its functions are stated in paragraph 15, item F, part 1 of that schedule to the state Constitution is to organize, undertake, and supervise elections, including election to the offices of the President and Vice President, among other political offices listed. Being a creation of the Constitution, INEC is empowered by Section 161 of the Constitution to make its own rules or otherwise regulate its own procedure, and in so doing it shall not be under the control of the President. Indeed, by Section 158(1) of the Constitution, INEC shall not be subject to direction or control of any authority or person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has enacted the Electoral Act 2022 to regulate the conduct of elections in the federal, state, and area councils of the Federal Capital Territory. Section 47(2) of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of registered voters and the results of the ballot in the manner as prescribed by the Commission. Section 62(1) of the Act specifically provides that after the recording and announcement of the results, the presiding officer shall deliver them along with election materials under security and accompanied by the candidate or their agents where available to such person as may be prescribed by the Commission. Further, Section 64(4) says that a collection officer or returning officer at an election shall collect and announce the results of an election subject to his or her verification and confirmation that a number of accredited voters stated on the collected results are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47(2) of the Act, and B, the votes stated on the collected results are correct and consistent with the votes or results recorded and transmitted directly from the polling units under Section 64. At this stage, it should be noted that Section 47(2) referred to in Section 64(4)(a) relates to procedure for accreditation of voters by the presiding officer using the technological device prescribed by the Commission. As for Section 64, referred to in Section 64, paragraph 4B of the Act, it only mandates the presiding officer to count and announce the result at the polling unit. In fact, Section 5 or Section 60 goes ahead to mandate the presiding officer to transfer the results, including total number of accredited voters and the results of the ballot in a manner as prescribed by the Commission. The Act also provides Section 60, subsection 5, that the collation officer or return officer shall use the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 of the Act, and the votes or results recorded and transmitted directly from polling units under Section 64 of the Act to collect and announce the results of an election if the collected result at his or her lower level of collation is not correct. From the affirmation section, it is clear that while subsection 4 of Section 64 provides for what the collection or returning officer will use to verify and collect the results, subsection 5 also provides for what the collection or return officer will use to collect the results. Subsection 6 of the same section provides for what the collection or return officer will use to determine the correctness of disputed results where there is a dispute. These are the original of the disputed collected results for each polling unit where the election is disputed, which in our view means the physical or hard copy of the disputed collected results. B, the technological device used for accreditation of voters in each polling unit where the election is disputed. C, the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 47, sub 2 of this Act. And D, the votes and results of the election recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 60, subsection 4 of the Act, which requires only the accounting and announcement of results at the polling unit. A careful examination of the above sections relied upon by the petitioners show that the Electoral Act had used the word deliver in Section 61, transfer in Section 65, and transmitted directly in Section 50, sub 2, 54, sub 4, 5, and 6 of the Electoral Act in stating how results elections should be handled under those provisions. A look at the definitions of those words in the Black Law Dictionary, 5th edition, show that the word transfer is defined at page 1497 as to convey or remove from one place or person to another, or to pass or hand over from one to another, or to specifically change or to schedule change over the possession or control. The word transmit, on the other hand, is defined by the same law dictionary to mean to send or transfer from one person or place to another, or to communicate. In my view, the Electoral Act 2022 has used the word deliver, transfer, and transmitted directly interchangeably to describe how the results of the election shall be moved from one stage to another until the results are finally collected and declared. In all this, the Electoral Act 2022 has not specifically provided that the results of the election shall be electronically transmitted. It is in the exercise of its powers under Section 160, subsection 1 of the 1999 Constitution, and Section 148 of the Electoral Act 2022 that the same respondent herein made the regulations and guidelines for the conduct of the election 2022 as well as Annex Manual for Election Officials 2023. In paragraphs 14A and 18A of the regulations, the same respondent prescribed by model voter accreditation system, DIVA, as the technological device for the purpose of accreditation and verification of voters in the 2023 general election. The petitioners have also changed their allegation on non-compliance on paragraph 38, 1, Roman 1 and 2, 48A, B and C, 50, Roman 5, 7 and 20, 51, Roman 2, 54, Roman 12, and 55, Roman 12, and paragraph 93 of the regulations and guidelines. Paragraph 38, those positions referred to have been reproduced in this judgment. So from the foregoing provisions of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in Section 621 for the delivery by the presiding officer of the results, along with other election materials under security and accompanied by candidates or their polling agents, were available to the third person as may prescribed by the first respondent. The first introduce electronic transmission to a collection system in addition to the fiscal transfer of the election results to the registration area toward collection officer. As stated earlier, the technological device prescribed by ANIC in the conduct of the 2023 election is the bimodal voter accreditation system. The functions of viewers are stated in paragraph 14A and 18A is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or fingerprint or face, thus facial recognition, thus accrediting the voter to vote at the election. And storing the data and number of such accredited voters. By paragraph 38, Roman 2 and 3 of the regulation, the device is also to be used by the presiding officer to upload a scanned copy of the EC88 to the annual result viewing portal, after which the presiding officer shall take the device and the original copy of each of the forms to the registration area, the ward collection center. From the above functions of the device, it is clear to me that apart from using the device to scan the physical copy of the polling unit result and upload them to the result viewing portal area, there is nothing in the regulation to show that the device was meant to be used to electronically transmit or transfer the results of the polling unit direct to the collection system. It will be noted that any results viewing portal area is not the collection system. Thus, the Supreme Court in Oetola and ANIC has explained system and area, where again JSC came as follows. As their name depicts, the collection system and the early result viewing portal are part of the election process and play particular roles in that process. The collection system is made of the centers where results are collected at various stages of the election. So, the polling unit results transmitted to the collection system provides the relevant collection officer the means to verify the polling unit results as the need arises for the purpose of collection. The results transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results at the election day close of court. A community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of election 2022, and the Annex Manual for Election Officials 2023 show that the Electoral Act expressly provides in Section 621 that after recording an announcement of the results, the presiding official shall deliver same along with election materials and the security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines as well as the Annex bylaws also state that hard copies of election results shall be used for collection, and it is only where such hard copies of the election results exist. No such hard copy of the election results exist that electronically transmitted results or results from the Annex will be used to collect the results. I had earlier said that the non-compliance that can significantly affect the result of an election must be such that is substantial enough to cause the court to invalidate it as prescribed by Section 135 of the Electoral Act. The burden and standard of proof is primarily on the petitioners to establish the existence of those facts or allegations asserted by them. It is important to note here that although election petitions are sui generis, they are governed by Evidence Act as well. Where therefore an election petition is founded on allegations of non-compliance, as in the instant case, from the myriad of decisions, the onus is directly on the petitioners not only to establish that through credible and compelling evidence, they have to go further and demonstrate through credible evidence that the non-compliance was substantial and that the non-compliance truly affected the results of the election to warrant their being annulled. See Akilla Day and others, another but Anik, Audu and Anik, Kote versus Mexico, Kempe and Ishaku, Nda Chene and Adamu and others. The Electoral Act made provision for declaration of results and the posting of results of the election. This Section 66 and 68 of the Act, which have been produced in this judgment. By the law, the results are declared by the counting of votes cast in the election and in accordance with the constitutional provision for the election of the president as in section 133 and 134 of the Constitution. The votes so counted and collected are the votes cast at the polling unit. Let me underline here that the conduct of an election, in the conduct of an election, certain processes must have been worked over to conclude and confirm that the election was conclusive. The steps outlined by the law must not be broken. These steps are accreditation, conduct of polls, counting of votes, collection and announcement of results, signing of result forms, and publication of results. The results sought by the relief sought by the petitioners are declaratory in nature. It decides a law that where a petitioner seeks a party seeks to declare relief, the burden is on him to establish his claim. His success is on the strength of his own case and not on the weakness of the defense of the respondent or defendant. The omissionary and Arabicola and Oga versus Piazzi. It is also the law that the pleading and the claim of the petitioner determine the burden and the standard of proof that is required. By Section 135 of the Evidence Act 2011, if the commission of a crime by a party in any proceeding is directly in issue in any proceeding, civil or criminal, it must be proved beyond reasonable doubt. See the application of this provision in the cases of PDC and IG versus PDC and others, APC and another versus Obaseki and others, Suleiman and others versus APC and others. In all these cases, the position of our law is that whenever crime is alleged, even if the case is a civil case, its proof must be that of beyond reasonable doubt. In the instant case, the petitioners have grounds of non-compliance with the Electoral Act 22 and allegation of corrupt practices. Section 134(1)(b) refers to the ground of corrupt practice or non-compliance. If the ground pursued in any petition is strictly non-compliance with the Act and there is no tincture of allegation of crime, the proof required would be on the balance of probability. But the standard of proof in any ground that is primarily on corrupt practice would require proof beyond reasonable doubt that allegation being criminal in nature. In the instant case, and on the issue being resolved here, the petitioner tendered some documentary evidence directly from the bar. The objections to the results of most of the documents had earlier been dealt with by this court in the earlier ruling on the objections as to the admissibility of the documents, and some of them have been held inadmissible in evidence. The petitioner called two star witnesses alongside other witnesses. The star witnesses are PW19, Dr. Alex Adum Tar, and PW22, Senator Dino Melai. The sworn evidence on oath of PW19 is at pages 131 to 160 of the petition. In paragraph 23 and 30 of his sworn deposition, Dr. Tar, that's PW19, said as follows. I know that on the face of the form EC8 in bracket, there are calculation errors as shown and contained in the report of the statisticians, which the petitioners shall rely upon. The non-compliance consists of refusal to authenticate all the intending voters in the election using the technological electronic device prescribed by the first respondent. In addition, the failure of the first respondent to transfer the outcome of the election directly into the portal of the first respondent created for the viewing of the public as a means to ensure the integrity of the election at the polling unit and the electronical collation system before the declaration as to who is the winner of the election. There are no particulars supplied in his statement on oath. All that can be read from this statement are projections without substance. When he was cross-examined by A.B. Mahmoud Essel, he said that it is true that I am a lawyer and politician. I am the national coordinator for the petitioners. I was at the National Collation Center. I was throughout the cross-examination of that witness has been reproduced a bit then they shown the position on oath of the next star witness or the petitioner, PW22, Senator General Milai, is almost a rehash of the entire petition. What he said on cross-examination by A.D. Mahmoud has also been reproduced. The testimonies of these star witnesses under cross-examination aggregated the same account given by other witnesses that the election went well. Accreditation with the Vivas device was all right. The agents of the petitioners were on ground at the polling unit, and that the results were entered on Form PC-88 and duplicate copies given to the agents. The facts elicited from the cross-examination of these witnesses have belied much of the terms of their written statements on oath. This, of course, is a challenge to the credibility of the evidence of PW19 and PW22. While cross-examination has the capacity to challenge the credibility of the witness, it also has the corresponding capacity of strengthening the case of the opponent. In the instant case, the evidence elicited from the PW19 and 22 on cross-examination has fortified, in my opinion, the case of the respondent that there was nothing wrong with the results of the 2023 presidential election and that there was substantial compliance with the Electoral Act 2022. That also played out in the cross-examination of PW20, Walatinji Oshele. His reposition on oath is at page 204 to 207 of the petition. That is the same trend in the account of these witnesses. They were majorly given account of not only the polling station they voted, but other places not within their reach. The significant point is that they testified of casting their votes without any problem. The results by their admission were properly declared and taken to the vote collection centers. The irony though is that the witnesses did testify to a peaceful and valid election in their polling units where they voted and then turned around to give evidence of alleged infractions in polling units where they were not present. Their testimonies in that respect are hearsay. Hearsay evidence is not admissible and has no value in proving the petition filed by the petitioners. Furthermore, in the instant petition, first respondent consistently maintained that the technical glitch that occurred on the election day was the failure of the e-transmission server to upload polling unit results for the presidential election into the IRS portal. It claimed that the glitch only prevented the members of the public from viewing or accessing the results that were already uploaded and listed on the first respondent e-transmission system. On their part, the petitioners asserted in their petition that the glitch claimed by the first respondent was actually a bypass by the first respondent to kill and switch the results of the presidential election in favor of the second and third respondents, as pleaded in paragraph 40. In furtherance of that assertion, the police also pleaded in paragraph 41 and 42 of the petition as follows. The petitioners applied to the court for subpoena to issue to the witnesses listed in paragraph 41 and 42 of the petition on 26/5/2023. These witnesses were not called by the petitioners, and no reason was given as to why they backed down from calling the witnesses they pleaded to call in proof of their petition. It described that litigation, particularly election dispute litigation, is fought on pleading. Parties swim or sink with their pleading. For this, see the case of Anyakulu and others versus Meta and others. See also Isai Ishiku Osandu Company Limited and another versus ITJ. Those pleadings from paragraph 41 and 40 of the petition having been abandoned as discountenance. In the same vein, paragraph 92 of the petition averts that the agents of the second and third respondents disrupted the election. Vote codes were not accurately recorded and the ballot papers were torn. The petitioners avert that video recording shall be tendered. However, the video recording was not tendered in that regard. In this respect, the presumption in Section 167B of the Evidence Act 2011 that they withheld the said video recording because it is against them if tendered shall also apply. From the foregoing example, it is very clear and certain that the petitioners have failed to prove that the 2023 presidential election and return of the second respondent was invalidated by reason of corrupt practices or non-compliance with the Electoral Act 2022. This issue, that issue 1, is therefore resolved in favor of the respondents and against the petitioner. Issue 2 is whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 26th day of February 2023, he having not scored one quarter of the ballot of the total ballot vote cast in the federal capital territory, Abuja. This issue has been resolved in petition number 3, and we adopt our findings and conclusions in that regard in this petition. It was. Issue 3 is whether second respondent was not qualified under the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended to contest the presidential election held on 26 February 2023, having regard to the alleged order of forfeiture arising from drug-related offense, is acquisition of the citizenship of the country other than Nigeria and presenting a false certificate to the first respondent. I do not intend to reopen this issue, having already ruled on it while considering the objections of the respondent. I held therein that the petitions did not plead facts in support of non-qualification or disqualification of the second respondent in their petition, and their efforts to remedy it through their replies to respondent replies were belated and ignored them. That ruling constitutes issue exception, binding not only on the parties but on this court, meaning that this court cannot depart from their earlier ruling. So this issue is therefore discontinued. This issue, yes, this issue is whether second respondent was elected by majority of local vote cast in the election, and first respondent was right in declaring him as elected. Covers ground 3 of the petition. The facts in support of this ground were pleaded by the petitioners from paragraphs 105 to 145 of the petition. The petitioners pleaded in paragraph 106 to 107 as follows. The petitioners shall leave evidence at the hearing to show that A, The result of the election as announced by the first respondent, and especially the votes allocated to the second respondent, do not represent the lawful valid votes cast at the election. And B, the lawful votes cast at the election were deliberately and massively deducted from the first petitioner's court by the first respondent in order to return the second respondent. 17. The petitioner shall give evidence to show the election results as purportedly declared by the first respondent in respect of each state of the federation, including the Federal Capital Territory, the details of which are contained in the table following are wrong. The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So why the complaint in an election petition is that candidates returned did not poll majority or highest votes in the election to be returned as contended herein by the petitioners. Not only must the figures disputed be pleaded, the figures or votes the petitioners perceive as the correct figures of the election ought to be true and must also be pleaded. That is not only logical. Support for it can be found in several decisions, among them Nadabo versus Dabai, where Okoro Jesse, as the then was said, when a petitioner is alleging that the respondent was not elected by majority of local votes, he ought to plead and prove the votes cast at the various polling stations, the votes illegally accredited to the winner, and the votes which ought to have been deducted from the supposed winner in order to see if it will affect the result of the election. Where this is not done, it will be difficult for the court to address the issue. See Awolo and Shagari, close of court. See also Ojo versus Ikoze and others, Taba Jesse as the general. The affirmance of petitioners in paragraph 107 of petition only shows the votes declared by ANEC, which the petitioners are disputing as manipulated. Nowhere in the petition did petitioners plead that is what they considered the authentic vote of the election to guide the court in the inquiry suggested by them in this allegation. The second respondent did not poll majority of local votes in the election. Their petition therefore did not meet the legal threshold to ignite the proper inquiry by this court, and so length even on the pleading. Going further, if we must at all, the petition claim is that 19,702 vote polling units results contains various forms of infraction. They assert that the results from a total of 4,307 polling units are without stamp on the respective form PCSA from the state, and details are said to be in the statistical report, which report we have repeatedly held incompetent and inadmissible. They also contended that results from 1,300 polling units do not have signatures of the presiding officers on the respective forms PCSA. It was also alleged that results from 6,408 polling units have and indicate zero accreditation. It was further alleged that 9,464 polling units across 30 states showed that the votes returned are in excess of accredited voters. Furthermore, that the presiding officers failed to properly seal and countersign alterations in election forms, including from EC8A, EC8B, EC8C, and EC8D in over 40,000 polling units, which they claimed were in the statistician's report. It is clear from the affirmance in the petition as captured above that neither the particulars of the polling units in issue nor those involved in the irregularities were given by the petitioners. In any case, our law is well settled that before a party can legally rely on fraud or forgery or any form of malpractice as alleged in this petition, the facts must not only be pleaded by but particulars thereof must be provided in the pleading. The petitioners in the pleading from paragraphs 128 to 142 about the issues of violence and disruptive activities. These allegations are criminal in nature. The standard of proof where an allegation of crime is made in an alleged position is beyond reasonable doubt and not on the balance of probability. See Emmanuel and Umana. A complaint of massive suppression, deduction, and allocation of votes connotes forgery or fraud, particulars of which must be pleaded and proved beyond reasonable doubt. See Kachi and KDC and others, First, the respondent joined issues with the petitioner's allegations in paragraph 92 to 142 of the petition. The second respondent and the third respondent in a similar manner joined issues with petitioners in calling on them to prove their claims as required by law. What this entails is that the petitioners who made all these allegations have the burden to prove all their allegations as required by law. The petitioners have placed live on the evidence of their statisticians and forensic experts who are TW21 and TW26 respectively. Had time to look at the evidence of these witnesses and had ruled that their evidence, apart from being improperly before the court, is also hearsay. The statistician's report rolled out figures of forms which he claimed were either not signed or stamped, but none of the forms referred to was attached to the report. The polling unit agents of the petitioners who were present in all the polling units around the country were not called to testify to any problems or difficulties in their polling units on the 25th day of February 2023 presidential election. That is vital to the petitioner's case. Thus, in Delgore versus Ahmed, it was said by Taba JSC as follows in the lead judgment. With respect to the volume of documentary evidence, I wish to state at the risk of repetition that they were merely tendered across the bar by Land Council for the petitioners at the time. It did not and was not in a position to answer questions or otherwise speak on any of them. Their makers were not called. In such circumstances, was the trial tribunal bound to ascribe protective value to them? I shall answer this question in the negative. The trial tribunal had no duty to accord protective value to the mass of documents, their status as certified documents notwithstanding. There is no doubt that the petitioner's decision to tender the mass of documentary evidence at the trial was prompted by the urgency dictated by Section 2856 of the 1999 Constitution as amended. That, however, does not diminish the petitioner's or appellant's burden and standard of proof of the petition. They had the duty to prove their petition according to law, close of court. This portion of the law may have been fairly watered down under the current electoral regime by Section 137 of the Electoral Act 2022, stating that it shall not be necessary for a party who alleges non-compliance with the provisions of this Act for the conduct of elections to call oral evidence if original or certified true copies manifestly disclose the non-compliance alleged. But even at that, it cannot be said that oral evidence is necessary to explain discrepancies in original or certified true copies of election documents, while the complaint verges on whether an alteration or amendment in the original or certified true copy of a polling unit result was made with intent to falsify it, or whether it was simply made to correct an apparent human error in the course of making entries in the result. Such situation would surely need a witness to explain or speak to the document in order to prove falsification of election documents when it is so alleged, as pointed out in Belgolid and Ahmed. See also the case of Wazir Ibrahim al-Shadari and Buhari Obasanjo. All the above, in my view, also explain the rationale for the employment of the adverb manifestly by the draftsman in Section 137 of the Electoral Act 2022. What the word suggests is that the non-compliance complaint of must be apparent on the face of the electoral document. It must not be something that can be explained away by oral evidence one way or the other. I have in this judgment explained the issue of evidence of witnesses who were not polling unit agents. The collection agents of the parties who testified were given accounts of stories related to them by people who were not called as witnesses in this petition. interpretation of Section 137 of the Electoral Act 2022 by the petitioners was generously and swiftly silenced, has generously and swiftly silenced the otherwise potent adverbial word manifestly used by the legislature in that section of the law. Manifestly is defined by online dictionary to mean in a way that can be readily seen by the eye or understanding, with the understanding plainly or obviously, evidently close, of course. This means for the petitioners to throw up their arms and say we need not call oral evidence, improving non-compliance as they are conversing. The certified copies of documents presented must be manifestly and readily seen to convey the fact of the fact of non-compliance. We have started this approach with Hitler and Anik, but the registry. From this authority, it is the law that where the documents tendered and relied upon by the petitioners do not manifestly disclose the non-compliance alleged, the petitioners will still need to call witnesses who witness the alleged acts of non-compliance to testify. In the instant case, the petitioners tendered loads of certified copies of the document. The petitioners filed 5 schedules of documents. The first schedule was filed on 30th May 2023. The second was 31st May 2023. The third was 2nd June 2023. The fourth was 7th June 2023. And the fifth was filed on 21st June 2023. From these schedules of documents, a lot of exhibits were generated and tendered. These exhibits were objected to by the respondents. I had earlier in this judgment dealt with the documents and objections. However, I want to have a look at these documents to see if they manifestly show any lack of compliance. These exhibits include the following: Exhibits PG1 to PG3, which were the print out of bimodal water acquisition system, rivers for Abia, Adamawa, Upper Ibom, Anambra, Bauchi, Bayelsa, Benue, Borno, Cross River, Delta, Ebonyi, Edo, Ikiti, Enugu, FCT, Abuja, Gombe, Imo, Jigawa, Kaduna, Kano, Katsina, Kebbi, Kogi, Kwara, Lagos, Nasarawa, Niger, Ogun, Ondo, Osun, Oyo, Plateau, Rivers, Sokoto, Taraba, Yobe, and Zamfara were admitted or objected to. Exhibit PH1 to PH36, which were the earning data on number of registered voters and collected PVCs for the 2023 general election for the state, listed in the first schedule of documents as numbers 46 to 82 were admitted. The second schedule of documents was filed on 31st May 2023, and the documents listed here Surprisingly, the documents were dumped on the court without any witness linking them up with the specific complaint of non-compliance. It is certain law that despite the tender was actually to proof of a petition, the onus of proving the case pleaded and for which the documents were tendered in evidence lies on the petitioner. In the instant petition, a lot of documents were tendered from the bar. When a party decides to rely on documents to prove his case, there must be a link between the documents and the specific areas of the petition. The party must relate each document to the case for which the documents were tendered. Failure to bring the documents is fatal and catastrophic, as it is in this case. The Supreme Court, in the recent case of Tumbi Bido versus Ani, started the question. In this situation, it is invariably correct that all the allegations raised in this petition have not been proved as required by our law. See Buhari and INEC, part told the JSC. It is also important to draw our mind to the fact that criminal allegations are usually and directly made personal. For allegations of crime to be proved against the respondent, it must be proved that they committed the corrupt act or aided, abetted, consented to, or procured their commission. Furthermore, it must be proved that the corrupt practices substantially affected the outcome of the election. The The law also places the onus on the petitioner to demonstrate by credible evidence that the alleged corrupt practice indeed occurred and that it affected substantially the outcome of the election. In that case, the petitioners pleaded some states where the malpractice allegedly occurred. One of such states is Sokoto State. They placed TW19, TW21, and TW22 to prove the allegations that the first respondent cancelled results from 241 polling units in Sokoto State in respect of National Assembly elections in the state, but went ahead to declare results for the presidential election. The three witnesses, TW19, 21, and 22, were not in Sokoto during the election. There is also no evidence tendered of the cancellation of results in any of the units alleged. TW19 and TW22, when cross-examined, said they were in Kogi State, where they voted, and later came to Abuja. The TW21 is the statistician who testified of overvoting, non-signing, and cancellation of form use, but he did not tender or show those compromised forms. The same occurred in their testimonies in Kano State, Kogi State, Lagos State, and River State. From the foregoing consideration, it is very clear that there was no credible evidence by petitioners to prove the allegations of corrupt practices. Under this issue raised, the petitioners were asking if the first respondent was not wrong in returning the second respondent when she was not duly elected by majority of local votes cast in the election. From the first place before the court, the first respondent declared the results of the election by which the second respondent was to return. Section 1342 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case. Not majority of votes cast as propounded by the petitioner. The first respondent was therefore right from the results declared by her, in the absence of any rival or alternative results placed before this court by the petitioner, that the second respondent, who scored 8,794,722 votes, as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of local votes cast in the election. It will vote its opponent result against the petitioners and in favor of the respondent. Having resolved all the votes about the four issues against the petitioners, I find that the petitioners have successfully proved any of the grounds as laid out in paragraph 16 of their petition. It is my conclusion that this petition also lacks merit. Having considered and decided that the three petitions, number 3A from PEPC 03-2023, CAPEPC 04-2023, and CAPEPC 05-23 are all devoid of merit, the petitions I hereby dismiss. Accordingly, I affirm the declaration and return of Bola Ahmed Tinubu by the Independent National Electoral Commission (INEC) as the duly elected president of the Federal Republic of Nigeria. The parties in the three petitions are to bear their respective costs. So now I will call on my learned brother by immediate right, which is only judgment. My you. Please sit down, sit down. Thank you, my Lord. I was privileged and privy to be part of the decision and the judgment elaborately given by my Lord presiding Honorable Justice Haruna Somani, and I'm in full agreement with the lead judgment as delivered by him in these three consolidated petitions, which are petitions number CAPC 03-2023 and CAPC 04-2023 and CAPC 05-2023. I agree also with the consolidated rulings on the various objections and other interlocutory applications relating to the competence of witnesses and the documents tendered in the three petitions highlighted. I also agreed with the reasoning and the conclusions arrived at the rulings on the preliminary objections and the substantial issues raised therein. In any concluded election, there are bound to be a winner and losers. While the winner celebrates victory, an aggrieved loser may come before the court to ventilate his grievances. This is made possible by the Constitution of the Federal Republic of Nigeria, 1999 as amended, which in Section 6 thereof empowers the courts to determine disputes, including election disputes. It is well settled that an election petition by nature is sui generis, of its own kind or class. It is not like going to court to make a claim of debt, contract, or tort. It has its own character, and is unique by its nature. The slightest non-compliance with the procedural step, which otherwise could either be cured or waived in ordinary civil proceedings, could result in a fatal consequence to the election petition. There are a lot of authorities listed there. Election petition as a special proceeding is specifically regulated by the Constitution of the Federal Republic of Nigeria, the Electoral Act, and other rules of procedure, such as the Federal High Court Civil Procedure Rules, the practice direction of the Honorable President of the Court of Appeal for the hearing of the election petition and for the hearing of election petition and the election petition appeals. By Section 285(5) of the Constitution, an election petition shall be filed within 21 days after the date of the declaration of results of the election. By Section 285(6) thereof, an election tribunal shall deliver its judgments in writing within 180 days. These timelines are sacrosanct and cannot be extended by the court. It is tried law that under the first schedule, under the first schedule of the Electoral Act, the election petition to be filed is well regulated. Paragraph 4, 5, and 6 of the Electoral Act provides that the election petition shall be accompanied by a list of witnesses that the petitioner intends to call in proof of the petition. 2, written statements on oath of witnesses. 3, copies or lists of every document to be relied on at the hearing of the petition. The petition which fails to comply with subparagraph 5 shall not be accepted for filing by the Secretary. An election petition which does not comply with subparagraph 1 or any provision of that subparagraph is defective and may be struck out by the tribunal or the court. The word shall used in this legislation makes it mandatory for a petitioner to comply with the provision of the law in pursuing or prosecuting election petition. Failure to comply is fatal. Election petitions are fought on pleadings, competent and credible witnesses. When a petition is deficient in pleadings and evidence, it is difficult to say it is proved, or it is difficult to prove the petition. In the recent case, the petitioner's pleadings were deficient. While they complained of non-compliance with the Electoral Act against first respondents, their own petitions were massively deficient in non-compliance with the said act. The lead judgment has elaborately dealt with these issues. When a court is called upon to determine an election dispute, he is called upon to do justice. Our notion of justice is doing justice is not that of doing justice according to the whims and caprices of the judges or the parties. It must be justice according to law. Justice according to law is also that which is neither based on technicality nor justice according to the suggestive clout of pressure groups, but as such as it substantially meets the demands of justice. This, with all respect, is what we have done in the lead judgment. I therefore concur with the leading judgment that these three consolidated petitions, having not been proved, are hereby dismissed. I abide by the consequential orders as made in the lead judgment. I will call on my land brother and make it left to deliver his own judgment.
I have read the lived rulings and judgments of my learned brother, H.S. Samani KCA, in the above consolidated petitions. I agree with his reasoning and conclusion in each petition and adopt same as mine. I add a few words for emphasis. Petition number 3. Ground 1 of the petition is that the respondent was, at the time of the election, not qualified to contest the election. The first complaint under this ground is that the purported sponsorship of the second and third respondents by the fourth respondents was rendered invalid by reason of the third respondent knowingly allowing himself to be nominated as the vice presidential candidate, whilst he was still a senatorial candidate for the Borno Central constituency. The controversy about the third respondent knowingly allowing himself to be nominated in more than one constituency was the subject matter in PDP against INEC and others, reported in 2023 LPELR 60457 SC. The Supreme Court Paukoro JSC, Augi JSC, Ogunmeju JSC, and Ajim JSC, in their concurring opinions, held that the third respondent, having withdrawn his nomination and personally delivered the notice of withdrawal to his party, fourth respondent in this petition, on 6th July 2022, he was no longer a candidate for Borno Central constituency senatorial election in his subsequent nomination as the vice president for the presidential election was not multiple nomination. The opinion of the Supreme Court of the Supreme Court, Paukoro JSC, Augi JSC, Ogunmeju JSC, and Ajim JSC, is not a comment or observation made in passing. It is an exposition of the law on withdrawal of a candidate from an election and the allegation that the third respondent knowingly allowed himself to be nominated as the vice presidential candidate while he was still a senatorial candidate for the New Central constituency. Concurring opinion forms part of the lead judgment, and it is meant to complement him by way of addition or an improvement on the issues resolved in the lead judgment. See Unwana against FCDA, Oloruntoba Oju against Abdurrahim, and both and others against Just Electricity Distribution Company PLC. Citations supplied. The Supreme Court having rendered its considered and definite opinion on the validity of the nomination of the second respondent as vice presidential candidates of the fourth respondent, attempts to reopen the issue in this court is a misadventure. The second complaint is that the second respondent was at the time of the election not qualified to contest for the office of the president, as he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C 4483 on 4th October 1993. The contention of the learned counsel for the petitioners is that the order of forfeiture made by the court is a fine under Section 137(1)D of the 1999 Constitution of the Federal Republic of Nigeria. It is a settled principle of interpretation. When the words used in the provisions of the Constitution are clear and unambiguous, same must be given their plain and ordinary meaning, unless to do so will lead to absurdity. See Abebuja and other cases cited here. The context in which the word sentence is used in Section 137, 1D of the Constitution, connotes formal pronouncement awarding punishment after conviction for an offense. Conviction is a finding of guilt after an indictment, arraignment, and trial. See also against FRN, Mohammed against Olawumi, Modu against Federal Republic of Nigeria. Therefore, the words sentence, imprisonment, and fine used in Section 137(1)(d) of the Constitution definitely denotes only a punishment imposed on a defendant following an indictment, trial, and conviction for an offense. See Babangida Usman against the state. Citation supplied at 40 to 41. Sharif against Federal Republic of Nigeria. Citation supplied. In civil forfeiture or a non-conviction-based forfeiture proceedings, in civil forfeiture or non-conviction-based forfeiture proceedings, the government only needs to show by preponderance of evidence that the property is a proceed of crime or was used to facilitate a crime. Criminal forfeiture, on the other hand, is seizure of a property connected with a crime after obtaining conviction and as part of sentence or punishment for the crime. Civil forfeiture is not a conviction or verdict of guilt after an indictment, trial, and conviction. See Jonathan against Federal Republic of Nigeria, citation supplied, where the Supreme Court for Akaas ASC considered the provisions of Section 17 of the Advance Fee Fraud and Other Related Offences Act and persuaded by the decisions of the various courts across the world, held that civil forfeiture is an action in rem embarked upon when the interest of the government is merely to recover the proceeds of unlawful activity. The court also held that an application for interim forfeiture of property that is not predicated on conviction of the owner of the property will necessarily be an action in rem, because it is the recovery of the property that the law aims at. A forfeiture order by a foreign court can only be accepted and recognized by a court in Nigeria for the purpose of Section 137(1)(d) of the Constitution, if it is made after an indictment, trial, and conviction, and properly proved as required by Section 49 of the Evidence Act. In addition, the conviction and sentence must be shown to have been a product of due process of law. Compliance with the process of law has to be determined by the procedure and standard set by Section 36, subsection 5 and 6 of our Constitution. The forfeiture order being relied on by the petitioners has not been shown to be a result of a process similar to the one set by our Constitution for a trial of the defendant for an offense. The appellant counsel relied on Austin against United States, citation supplied, and Teams against Indiana, decided on 28 February 2019. The forfeiture proceedings in the two cases were instituted as part of criminal proceedings after conviction of the defendants. Secondly, forfeiture was regarded as punishment for the purpose of protecting the constitutional rights of the defendants against the imposition or infliction of excessive bail or excessive fines or cruel and unusual punishment for an offense. Eighth Amendment provides that excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishments inflicted. In United States against usury, 1996, other citations supplied, the United States Supreme Court considered the relationship between punishment and civil forfeiture. The court held that in rem civil property forfeiture did not constitute a punishment such as fine for purposes of double jeopardy clause of the Fifth Amendment. In Abacha against Federal Republic of Nigeria, citation supplied, forfeiture was also defined in the context of the doctrine of double jeopardy. The appellant contended that the state could not indict him and prosecute him for the offenses of conspiracy, receiving stolen property, dishonestly and concealing stolen money after forfeiting the properties listed under forfeiture of assets, PEPC, certain persons decree number 53 of 1999. The rejection of the plea of double jeopardy means that the court did not consider the forfeiture under the forfeiture of assets, PEPC, certain persons decree number 53 of 1999 as punishment. From all the above, it is clear that a non-conviction based forfeiture being civil in nature and an action in rem can in no way be equated with the sentence of imprisonment or fine imposed for an offence involving dishonesty or fraud or for any other offence to disqualify a person from contesting for election to the office of the President of Nigeria. An indictment, arraignment, trial, and conviction are necessary preconditions for disqualification of a person under Section 137(1)(d) of the Constitution. Grant 2 of the petition is that the election of the second respondent was invalid by reason of corrupt practices or non-compliance with the provisions of the Electoral Act. The allegations are basically predicated upon electronic transmission of the election. A global reading of the Electoral Act 2002, particularly sections 47(2), 61(5), 62(1), 65(1) to 8, will show that what the Act provides for is manual transfer and manual collation of results by collation officers at various physical collation centers. There is no provision for electronic transmission or IREF or electronic collation of results in the Act. By paragraphs 38 and 48A of INEC regulations and guidelines for the conduct of elections 2022, first respondents made provision for electronic transmission and physical stroke manual transfer of election results from the polling unit. However, paragraph 48C provides that if no result has been electronically transmitted from the polling unit, the provision of paragraph 93 shall be applied. Paragraph 92 categorically provides that at every level of collation, where INEC copy of collated results from the immediate lower level of collation exists, it shall be adopted for collation. By paragraph 93, where INEC hard copy and electronically transmitted results from the immediate lower level of collation do not exist, the collation officers shall use duplicate hard copies issued to the Nigerian Police Force and agents of political party to collect results. It is therefore not correct that it shall not be possible to collect results of the election where results have not been electronically transmitted. By law, the INEC regulations and guidelines for the conduct of elections 2022 is subordinate to the Electoral Act, where a provision of the guidelines conflicts with the Act. The Act prevails. See Odeneye against Funuga, against Peter citation supplied. Section 134(2) of the Act. By Section 134(2) of the Act, any circular, press release, promise, or stated intention of INEC that is in conflict with or expand the provisions of the Electoral Act cannot prevail over the Act. INEC guidelines cannot be elevated above the provisions of the Electoral Act so as to elevate electronic transmission of results over and above manual and physical transmission of hard copies and manual collation of results as prescribed or as provided for by the Act, to the extent that non-compliance with the regulation automatically invalidates an election. PW4, the professor of mathematics, presented to this court as an expert witness, confirmed under cross-examination that IREF is not a collation system. He also confirmed that whether or not transmission to IREF failed or the image of result on the IREF is blurred will not change the result entered onto Form ECAT at the polling unit level. Under cross-examination, PW12 stated that petitioners had 133,000 agents. He was not a party agent at any of the INEC designated polling units or collation centers. None of the 133,000 party agents was called to testify that there was a dispute regarding any collated result at any polling unit, registration stroke ward, local government, state or national collation centers. So as to enable the collation officers at the various levels of collation to activate the process prescribed under Section 64, subsection 6 of the Act. PW12 stated that the petitioners believed they have won the election. If they will have won the election, if the results have been uploaded. When asked about the score of the petitioners by which they claimed to have won the election, he answered rhetorically that how are they supposed to know the score when the results were still being uploaded on the IRA. So, this petition is about the belief of the petitioners that they will have won the election if the results had been uploaded on the IRA. Election petition is a serious issue. A petitioner is not permitted to engage in fishing expedition or a roving inquiry, as the petitioners herein did. It is clear from the pleadings and the evidence of PW12 that the petitioners were from the onset engaged in a wild goose chase and inquisitorial adventure. By paragraph 9 of the regulation, a political party has a right to appoint one person as its polling agent for each polling unit, collation center, and one representative at each point of distribution of electoral materials in the constituency where it is sponsoring candidates or candidates for an election. According to PW12, the petitioners exercise that right and add 133,000 party agents in the election. I stated earlier that none of those 133,000 polling agents was called, and not a single one of results forms collected by any of the agents was tendered in evidence. Electoral acts provided a candidate who wishes to challenge any result declared by INEC with a potent material, which are the forms on which results are entered, signed by the first respondent officials and party agents, and a duplicate copy of it is given to the party agent. Any serious candidate ought not to depend on INEC for materials to prosecute his petition. By Section 167D of the Evidence Act, the failure of the petitioners to produce election result forms collected by their agent raises a presumption that if those forms had been produced, would have been unfavorable to the petitioners. The first respondents in their pleadings and evidence through DW1 stated that the delay in uploading the results from the polling units to the IRF was due to a technical glitch which occurred on their transmission system, which was rectified within a few hours. All that the petitioners could do was to bring a PW1, a member of the second petitioner, who claimed to be a software engineer and an employee of Amazon. He had the temerity and the audacity to claim authorship of a document, a word of which does not belong to her. The first respondent never claimed that the glitch occurred on Amazon Web Services. It is obvious from PW7's evidence that the petitioners did not understand the explanation of the first respondent, or were just fixated on their belief that they won the election without any cogent and credible evidence. And they did not even bother to place any such credible evidence before this court. Were they expecting the court to go and gather evidence from the street or from the market, or to be persuaded or intimidated by threats on social media? That is not the way of the court. See the admonition of Toby JSC in Buhari against Yaradua on a similar situation like the instant case, citation supplied. Thus, the petitioners not only failed to prove non-compliance with the Electoral Act, they failed to prove that the non-compliance substantially affected the result of the election declared by the first respondent. It is settled that even if non-compliance with the Electoral Act is established, if there is evidence that despite the non-compliance, the result of the election was not affected substantially, the petition must, as a matter of law, be dismissed. See Abu Bakr and others against Yaradua, citation supplied. The third ground of the petition is that the second respondent was not duly elected by majority of lawful votes cast at the election, having not obtained 25% of the votes in FCT. The provisions of the Constitution must be read together to discover the intention of the framers of the Constitution. A court of law has no power to take away or limit the words of the Constitution or import into it what it does not say. CLLU, Abib, and another. Against the Honorable Attorney General of the Federation, citation supplied. A narrow interpretation that will do violence to the provisions of the Constitution and fail to achieve the goals set by it must be avoided. Our Constitution is based on principles of freedom, equality, and justice in all ramifications, and is for the purpose of consolidating the unity of our people. Section 41 and 2 of this Constitution, 14:1 and 2, states that the Federal Republic of Nigeria shall be a state based on the principles of democracy and social justice. The participation by the people in their government shall be ensured in accordance with the provisions of the Constitution. The right to vote is at the foundation of our democracy. It is the most potent and priceless opportunity a citizen has to have a say in who governs. Every citizen who is qualified to vote must be afforded equal opportunity to cast his or her vote to elect leaders who governs. Our constitutional principles of freedom, equality, and justice, democracy, and social justice means that the vote of each citizen shall count. Each and every vote should count equally. No vote should weigh more than the other. Principles of equality of vote must be protected by the court. The interpretation of Section 134(2) of the Constitution, urged on us by the petitioners, is an unjust manipulation of the Constitution to create inequality of votes. It negates the principle of equality and justice, democracy and social justice, and participation of the people in their government enshrined in our Constitution. It strikes at the very foundation of our Constitution. It is capable of further dividing the citizens of this country. The politicians are good at using all sorts of means and sentiments to divide the citizens of this country. The interpretation being urged on us is their latest invention in that regard, and unfortunately, we found a ready alliance in those who should know better. The interpretation being urged on us squarely against the letters and spirit of our Constitution, and it is hereby rejected. Based on the above and the further reasons lucidly explained in the leaked judgment, I too dismiss the petition. 04. I have had a preview of the reasons given in the leaked judgment of my learned brother. I agree and conclusion. I adopt same as mine. I hereby abide by the orders made therein. As for 05, I adopt my reasoning in respect of the third grant, and I also dismiss the petition. On the oath, I too dismiss each of the three consolidated petitions. I abide by the order made in respect of the petition in the leaked judgment.
My learned brother, by my extreme right, present that
had earlier read in draft the rulings and judgments of my learned brother, Aruna Simon Samani. These consolidated petition numbers CAPEPC 03, 04, and 05, 2023. I am in complete agreement with His Lordship's reasoning and conclusions on all of them. First, for petition numbers PEPC 04, 2023, that is the Allied People's Movement petition, I am of the very fixed view that the issues agitated by the petitioner therein concerning third respondents and alleged disqualification by reason of matters connected to and surrounding his joining list nomination and relinquishing of his earlier nomination by his party for the Boronu Central Selectoral District having been settled on their merit by the Supreme Court in its judgment in appeal numbers SCCV 501/2023, in third and first respondents' favor therein, with the apex court even holding that the said issue did not disqualify them, that decision constitutes issue estoppel, in status defining and so judgment in rem it binds every person, including non-parties to the suit, like the petitioner in petition number CAPC 04/2023, C. Kotun, and Orokomi, Soson, and Odemuyiwa. Furthermore, by the doctrine of stare decisis, it also binds this court. In fact, it will, in my humble opinion, amount to judicial heresy for this court to involve itself in inquiry by whatever guise into that same issue already settled by the apex court. Coming to petition number CA03/2020 of Peter Obi and another versus INEC and others, and CAPC 05/2023 Atiku Abubakar and another, again I am of the very fixed view that the two sets of petitioners did not by any means discharge the burden on them of proving that the results of the presidential election of 25th February 2023 as declared by first respondent were incorrect. Incidentally, their burden is even made heavier by the legal presumption that the votes of an election declared by the official organizing body that INEC is are correct. And it is for the person asserting the contrary to prove it. You are an INEC. You are an INEC. Even their resort to first respondent's failure to keep its initial promise of good only unit results of that election to its result due portal IREV real time, which failure the alleged evidence is election manipulation, does not help them. And specifically on this allegation of manipulation of election results, the point must be made that since it is their case that from the word go that the election results in issue were manipulated by first respondent in favor of second respondent, and specifically that the manipulation took the form of programmed failure of technological device, machines, that is beavers by first respondent by intercepting the results, quarantining, warehousing, and putting such results before releasing them to the IREF portal. Two, INEC replacing its in-house IT expert at the 11th hour with a rogue staff, all in a bid to completely control, monitor, and filter data transmitted from the beavers devices to the electronic system. And three, that Globacom, the internet provider for the beavers and electronic system, was also disconnected by first respondent to enable it to manipulate the results. With the petitioners in PA, that is the Atiku petition, even going further to undertake to call evidence to prove all those allegations. The burden of proof was on the petitioner to prove those assertions, and that is regardless of whether they are positive or negative. After all, it is they would have failed in the case if no evidence at all was adduced in their petitions. See on that sections 131 of the Evidence Act, Buhari and INEC, Aladegbe versus Pasomade, Elias and Disu Dashi and another Abrat and Railway, not the railway company. Taking all this time in making this point because of the argument of both sets of defendants that they only made negative assertions in their petition, when they alleged that there was nothing wrong with first respondent transmission system and IREF, so they had nobody to prove it. That the burden of proof was on the respondents who they said positively asserted glitch in real-time transmission of their results. Petitioners who directly made manipulation of its e-transmission system by first respondent to favor second respondent, the pillar of their case, cannot be held to say its respondents are not them that had the burden of proof in this case. Incidentally, that assertion of petitioners that INEC simply closed down or blocked its IREF and an e-transmission system for the public to enable it to manipulate the election results in favor of second respondents also takes me directly to the more important question in the petition, namely whether that allegation is even worthy of belief, given the results declared by INEC for them and the second respondent in the election. To answer that million-dollar question, I deem it necessary to resort to the probabilities arising from the facts of the case. That test, otherwise called the probability test, which test celebrated Judge Chukwudifu Akonne Oputa, JSC, always maintained, and I quote him, is the surest road to the shrine of truth and justice. In the cases of, he said so in the case of Didi Amaka and others, and in Ojibwe and others, the first 1989 and the second 1988. I gave the citation. Here, the assertion of petitioners is that test respondent INEC merely used the excuse of glitch in its IREP portal to block the public from seeing its polling unit results real time so that it could manipulate, and indeed actually manipulate, the 23 February 23 presidential elections in favor of second respondent. It is their further contention that the manipulation of IREP by INEC with the said phantom glitch in favor of second respondent was nationwide. The question is, do the results declared by INEC support that hypothesis? They say the taste of the pudding is in the eating. I shall therefore now try to walk us through some of these election results to see if that assertion of petitioners is supported by the results declared by INEC and so probable and worthy of belief. In doing that, I shall randomly pick on the results of some states of the Federation and the Federal Capital Territory. I shall be relying on the state summary of the results that from ECD declared by INEC and has also attached their petition by the petitioners in CAPC 05, that is Article's case, which result was also tendered by both sets of petitioners and respondents. So I take first Abia State. There, second respondent, the alleged favorite candidate of INEC, for which it was said to have shut down its IREP to manipulate results, only garnered a miserly 8,914 votes. That is as against the Labour Party, which by INEC's declaration polled as many as 327,095 votes. Even the other set of petitioners, complainants, the PDP and its candidates, scored more votes in Abia than INEC's purported favored candidate. He also scored 22,676 votes in Abia and was so recorded by INEC. Those votes alone are close to 3 times the votes of second respondents, for whom INEC was said to have manipulated results by closing down its IREP, so that the public would not witness its manipulative activities in favor of second respondents. In Enugu State, the same favored quote-unquote candidate, second respondent, was again declared credited by INEC to have polled only 4,772 votes in the entire state. Meanwhile, the Labour Party and its candidates were again declared by manipulative and quote-unquote and unfriendly INEC to have scored as much as 428,690 votes in that state. In the same Enugu, PDP and its candidate was also declared by INEC to have polled 15,745 votes, a number that is also nearly 3 times the votes of the so-called favored second respondent. In Anambra State, the same purported favored candidate, second respondent, was declared by his alleged friend INEC to have scored only 5,111 votes. Meanwhile, the Labour Party, whose candidate, first petitioner in CAPC, I must take judicial notice of, reading Section 124 of the Evidence Act is from that state, again was declared to have polled as much as 584,621 votes. Again, like Enugu State, the PDP and its candidate was declared by INEC to have polled 9,036 votes, a number that is also nearly double the votes of quote INEC favored and quote second respondent. In neighboring Delta State, the same INEC favored candidate, second respondent, was declared by INEC to have scored 90,180 votes. That is as against the Labour Party and its candidate, which is credited by the same biased quote-unquote INEC to have scored as much as 179,917 votes. In that same Delta State, the PDP and its candidate scored 161,600 votes, again nearly double the votes of second respondent. In Adamawa State of the PDP and its candidate, the same favored second respondent was declared by INEC to have scored only 105,648 votes, while the PDP and its candidate were declared by the biased quote-unquote INEC to have scored as much as 214,012 votes. In Imo State, the same purported INEC favored candidate, second respondent, was declared by INEC to have scored only 56,406 votes, while the Labour Party and its candidate is declared by the same INEC to have polled as much as 360,495 votes. In Ebonyi State, the Labour Party again scored as much as 259,738 votes. That is as against alleged INEC favored second respondent, who by INEC's declaration, that is his friend's declaration, Again, polled relatively miserly 42,402 votes. The PDP is said to have scored 13,503 votes there. Even in Lagos State, where second respondent was once elsewhere as elected governor, the Labour Party and its candidate was again declared by bias, quote and unquote, INEC to have beaten second respondent with almost 10,000 votes. The Labour Party was declared by INEC to have polled 582,455 votes as against 572,606 polled by second respondent and so declared by INEC. It is a similar story in the federal capital territory of Abuja, where INEC has its headquarters and supposedly carried out, directed all its quote manipulative and biased activities in favor of second respondent. That petition has claimed it in the election. Second respondent and his political party still up there. In fact, by the result, second respondent friendly, quote and unquote, INEC declared in the federal capital territory of Abuja. Second respondent could not even make 25% of the votes, total votes cast there. He was said to have polled 190,902 votes. That amounts to just 18.991% of total votes cast in the FCC. Yet INEC declared that result. That is as against 281,717 votes, amounting to 58.856% of total votes. The same INEC declared for Labour and its candidate. There are also other states, including Katsina State of the immediate past president of this country, a member of the second respondent, who was still in office at the time of the elections, a part of the judicial notice of video section 124 of the Evidence Act. There again, second respondent and his party, the APC, also the deputy president, was declared by the same INEC to have lost the petitioners in PEPC 05-2023, that is Atiku Abubakar. Now, if all these results declared by INEC for each of the states for the two sets of petitioners, and second respondent is anything to go by, then INEC must be an abysmally poor manipulator, if not even an specific one. Surely, it would not go through all the stress of closing down its IREF and blocking the public from seeing its manipulative efforts in favor of second respondent, as alleged by the petitioners, only for it to still end up favoring the petitioners with jumbo votes and posting miserly figures for its so-called second respondent. It is said that all men stamp as provable that which they would have said or done under similar circumstances, and as improbable that which they themselves would not have said or done under the same set of similar circumstances. Things inconsistent with human knowledge and experience are properly rated as improbable. End quote. See again Okuta GSC on this, Nonra and the state and Bozin and the state. At any rate, why did any of the two sets of petitioners not tender even a single polling unit result issued by INEC to their polling unit agents to support their claim of manipulation of election results by INEC? Even as they all agree that they had against the polling unit, I had thought that this is the best and most effective way of proving the manipulation of election results alleged by them. After all, the polling unit is the only place where voting takes place, and so also constitutes the building block of election results. That much is stated in paragraph 90 of INEC guidelines and for the election, and also Wood and Ono and Awusi and Odele. In short, the allegation of the petitioner that INEC shut down its IRF to manipulate votes for second respondent just does not add up for me. If anything, the probabilities arising from the results INEC declared nationwide as history, therefore rather seem to me to eloquently support this position that its inability to upload the polling unit results real time, as earlier promised, was not deliberate but caused by technical issues outside its control that afflicted its e-transmission system, which uses its claims made it impossible for its e-transmission system to map the uploaded polling unit results for the presidential election to any specific state. That is claimed is unlike the much smaller National Assembly elections that were conducted simultaneously with the presidential election. It is that phenomena it describes as glitch that was giving it an HEPP 500 euro, which eventually resultantly delayed real-time public viewing of the third polling unit results. That conclusion also takes me to another big issue in this case, namely the evidential value of the European Union Observer Mission report on the 2023 election and presidential election, over which quite a mountain has been laid up by both sets of petitioners. That report was tendered by the petitioners in petition number PEPC, that is and another, as Exhibit X2, and by the petitioners in PEPC 05 as Exhibit RA 27. The impression given by both sets of petitioners that the said report which in any case has been even admissible by us in petition number CAPEPC 03-2023, like gospel truth of what happened in the election. And so it must be accepted by this court, and the conduct of the presidential election declared corrupt or at the very least below par, regardless of whether or not these authors presented themselves in court to defend their opinion. That stance, I am afraid, is a non-sequitur, a complete non-sequitur. Without the makers of that report presenting themselves in court to face cross-examination, to authenticate their opinion, that report, and I dare to add even the ECOWAS report of the same election, tendered by second and third respondents in petition numbers in two petitions, are completely valueless and inadmissible for the purposes of authenticating the opinions expressed in them by the makers. See first from that the cases of Nyesom and Peter Said and Said versus Yakowa. It also makes no difference that the said reports have been put in the form of print. Books, it must be noted, cannot be cross-examined. On this, I find support in the celebrated case of Idudu and others versus Okumaga, where the Supreme Court, 1976, where the Supreme Court had this to say, and let me quote what the Supreme Court said. It said, as for the law involved in Idudu and Okumaga, we would like to point out that it is now well settled that there are 5 ways in which ownership of land may be proved. In our view, not only was the evidence of the witness that is continuation, not only was the evidence of the witnesses called by the appellants rightly rejected by learned trial judge for good and sufficient reasons, we also think that he was right in not attaching any weight to the views expressed in the book cited in support of such traditional evidence. As Lionel Brett JSC, as the then was rightly in our view once pointed out in a learned address given by him at the University of Lagos to the Nigerian Association of Law Teachers, Monaco today, the courts are not to be hypnotized by the authority of print. The crucial fact is that books cannot be cross-examined, either as to the opinions expressed or as to the claims of the author to have special knowledge. If the author is living, there is no reason why he should not be tendered as an expert when this difficulty would vanish. Of course, end quote on that side. Then the Supreme Court went on to say, moreover, none of the authors of these books in that Kumagba case testified in support of the justice stated therein, and no explanation was given for the omission. For all these reasons, we share the apprehensions of the learned trial judge about the value or weight of the traditional evidence as narrated by each of these authors, particularly as the authenticity and impartiality of the sources of the narratives cannot obviously means easily ascertained. I wanted to say that is the exact same situation we are confronted with here as regards both the European Observer Mission report and its broader ECOWAS election observer report. For purposes of proving the opinions expressed in them by their makers, neither of them is of any higher value than the mere sheets of paper on which it is recorded. And for those who, like the petitioners, are enamored by the now very familiar patronizing judgments passed on elections, regularly passed on elections, by European election observer missions every 4 years. Even as the same Europeans have maintained a deafening silence on the never-ending complaints of former President Donald Trump, that the year 2020 presidential elections of the United States that saw him out of every office was also a fraud, it may interest them to know that Sir Justice Lionel Brett, who made the comment cited approvingly by the Supreme Court in Okumagba's case that I read about, was also a European. He's British. He was British. I think I intend to stop here. I think I've said enough. It is for these few additions, but much more for the far more illuminating reasons advanced by my brother Haruna Saman against his rulings and judgments, which reasons I concur with without reservation. That I also hold all 3 consolidated petitions not proved and thereby enter another dismissing all of them, and I find the declaration of second respondent Bola Ahmed Tinubu by second respondent that the person duly and properly returned winner of the 26th February 2023 presidential election of this country and duly elected president of the Federal Republic of Nigeria. I also abide by all other consequential orders, including that as the court contained in the leading judgment.
I now invite my learned brother, Philip, to present on judgment.
Last but not the least, I've read before now the draft of the lead judgment just delivered by my learned brother Haruna Simon Samani, JCA, in the 3 consolidated petitions of CAPEPC 03-2023, CAPEPC 04-2023, and CAPEPC 05-2023. I'm in agreement with and I adopt all the reasons and conclusions stated therein, both in relation to the rulings on the objections and the merits of the three consolidated petitions. Although all the issues in petitions number PEPC 03 and 2023 and PEPC 05 2023 have been exhaustively resolved in the lead judgment, I deem it only pertinent to highlight the fundamental vice which has affected the two petitions, especially as it relates to the petitioner's essential contention or premise upon which they predicated those two petitions. In those two petitions, the petitioners have premised their ground that the presidential election conducted on the 25th of February 2023 is invalid by reason of corrupt practices and non-compliance on their contention that by the provisions of the Electoral Act 2022 and the regulations and guidelines for the conduct of elections 2022, the first respondent, INEC, is mandatorily required to electronically transmit election results to the coalition system and to the INEC results viewing portal, the AREP. They contended that the first respondent had deliberately refused to comply with those mandatory provisions and had manipulated the results of the election through various corrupt practices which they alleged in those two petitions. However, in both petitions number PEPC 03-2023 and PEPC 05-2023, exhibits X1 and X2, which were tendered respectively, to show that the Labour Party, the second petitioner in petition number PEPC 03-2023, had before the elections approached the Federal High Court Abuja for the determination that, and I quote, by the provisions of the Electoral Act 2022, INEC, the first respondent, has no power to opt for manual method other than the electronic method provided for by the relevant provisions of the Electoral Act, unquote. And I quote again, an order of this honorable court directing, like compelling the respondent to comply with the Electoral Act 2022 and the electronic transmission of results in the forthcoming general elections, unquote. In that judgment, the Federal High Court Abuja Division had dismissed the suit and held that, and I quote, there is nowhere in the above cited sections where the Commission or any of its agents is mandated to use an electronic means of collating or transferring of election results. If any, the Commission is only mandated to collate and transfer election results and number of accredited voters in a manner owing deemed by it. Additionally, this court's attention was referred to the judgment of this court in appeal number CA-LAG CV 332-2023, PEPC versus Labour Party and 42 others, delivered on the 19th of June 2023, in which this court set aside the judgment of the Federal High Court, Lagos Division, in another suit number FHC LCS 370-2023, Labour Party and others versus INEC, filed by Labour Party, the second petitioner in PEPC 03-2023, before the Lagos Division of the Federal High Court, to obtain an order of mandamus compelling INEC to electronically transmit or transfer election results as provided in its regulations, after losing in the Abuja Division of the same court. In the judgment of this court of 19th of July 2023, in appeal number CA-LAG CV 332-2023, this court particularly held at pages 23 to 24 thereof that, and I quote, it is difficult for suit number FHC LCS 370-2023, which gave rise to this appeal to escape the level of abuse of court process. I said so because the objective of the suit is to compel the 43rd respondent to adopt a particular way of transmitting or transferring the results of the election in Lagos State. This objective is not in any way different from what the objective of the first respondent wanted to achieve in suit number FHC ABJ CS 1454 2022. Similar parties are the same in the two suits. The second 42nd respondent are members of the first respondent, which litigated suit number FHC ABJ CS 1454 2022. The second 42nd respondent's interest is the same with that of the first respondent, so they are the first respondent's previous. Both suits are against the same defendant, that is the 43rd respondent hearing, and filed in the same court, albeit different divisions of the court. The decision of MAK Nwite J of Abuja Division of the lower court, which dismissed the first respondent's suit, holding that on the interpretation of the provisions of Section 60, subsection 5, 62, subsection 2 of the Electoral Act 2022, INEC, the 43rd respondent hearing, is at liberty to prescribe or choose the manner in which the election results shall be transmitted, finally settles the issue. I therefore find in suit number FHCLCS 370/2023, which is herein being appealed against all the trademarks of the cause of an abuse of judicial process, unquote. Exhibits X1 and X2, tendered in petitions number 03 and 05 respectively, as well as the decisions of this court in appeal number CA-LACV 332/2023, Supra, are sufficient judgments of court which are not only binding on the parties, but which constitute issue estoppel to the petitioner's essential contention in the two petitions, that the first respondent is by Electoral Act 2022 and the INEC regulations mandatorily required to electronically transmit and collect results of the presidential election. The doctrine of issue estoppel is that once an issue has been finally decided by a competent court, the issue will not be allowed to be litigated by the same or even different parties, see Cotton versus Wacom and another, PEPC versus PDP and others, Ezewani versus Onwodi, citations on the record. Indeed, in Ezewani versus Onwodi, the Supreme Court, Pauputa JSC, specifically held as follows. Strictly speaking, therefore, the concept and value of an estoppel is to bar a person from denying or asserting anything to the contrary of that which he has in the contemplation of the law been established as the truth, either by the acts of judicial or legislative officers or by his own deed or representation, express or implied, unquote. It is clearly evident that the decisions in Exhibits X1 and X2, tendered in the two petitions respectively, as well as the decisions of this court in appeal number CA-LADCV 332/2023, APC versus Labour Party and 42 others, have dealt a death knell to the petitioner's contention around which they have built their claim of non-compliance and corrupt practices in those two petitions. Namely, that the first respondent is by the provisions of Electoral Act 2022 and the regulations and guidelines